I'm very obliged.
Again.
Item number 3, Sri Sholai Malai Pichai Anand versus Mrs. Excite Industries Limited.
Milord, I had initially taken the points of one section 21 notice for Milord multiple agreements and Milord a question of limitation also. I think Milord Lordship can keep all those points open and Milord appoint the arbitrator. Milord limitation.
One section 21 can I keep open? I mean,
Lord,
the other point, limitation definitely has to be.
Milord, if
Lord,
What is your answer to 121?
with regard to 21, my lord, I have referring to your lordship's recent judgment passed on 19th April, my lord, in the matter of Gantex India Green
The
Limited.
argument.
Lord, that there is no bar in one section 21 notice, even in respect of several contracts. Although my submission
has
is
to be a
composite
link.
contract. So, my lord, these
Lord,
Lord, will kindly have a
Milord, the respondent here was appointed as the the petitioner is appointed as the clearing agent, Milord, in respect of 4 separate Milord ports or areas. 4 separate areas, 4 separate agreements. They, Milord, seek default or breach on my part, Milord, in respect of all 4 outstandings in respect of all 4. In respect
same
of
subject matter, same.
subject matter is not the same.
Lord, will
Parties are
kindly
the
have a
same,
look at.
but
Lord,
subject
So
matter.
there was some link in that matter.
Yes, Milord.
Some link was there.
Lord, that was
Anything
in
from the
respect
same
of.
tender or whatever.
No, my lord, will kindly have a look at this minute. I'm sorry, my lord, I'm only.
Right.
Yes, but it was qualified. If there is a dispute and difference, if the bundle of facts which give rise to the same chain of cause of action is the same for all the agreements.
Lord, in
But the
this
same chain
matter also, my lord, in my humble submission,
is the
there was a
chain?
link. First and foremost, my lord, pursuant to negotiations, the respondent had given us contracts in respect of as agents in respect of 4 different warehouses of the respondent in respect of the same transactions, goods.
What is the similarity? Show me from your application.
And my lord, even my lord,
Warehouses are different.
only the
Parties are
warehouses
only
are
same.
different. Parties are same. The goods in respect of which the contracts were given also same.
Goods are same.
And yes, and in fact,
Same or similar?
No,
Same
similar.
goods?
similar.
Can't be the same.
In fact,
Yes.
they had made an acknowledgement of liability of 1 crore and odd. That was also by way of a single letter. And they admit that a consolidated amount of 1 crore and 7 lakhs was due and payable. But I'll take
Mr.
lordship.
Mitra, come back tomorrow. I'll hear you. If you have
86.
difficulty today, I'll hear on this point only.
Very well. Very well.
I'll hear on section 21
Very
point
well.
only.
Very well.
Because that the court has to satisfy itself also. On that. Limitation,
Because,
very well we can.
Yes, Milord, that can be dealt with by the arbitrator.
Definitely. But section 21, there cannot be any section 11 then.
Without a 21, there can't be 11. So, Milord,
Without a proper 21.
yes, without a
Should be read into. So I'll take it up tomorrow if you have difficulty today. Or let it be in the list. Let it be called on. If it is called on. If you are not there, I'll consider that. I'll put it tomorrow.
I'm very grateful.
It a passover rule.
One.
Grateful. Lord.
Item number 1, Chandan Chatterjee and others versus Geeta Sundara Raman and others.
Yes.
Lord, I'll be very brief, my lord, and proceed on the caveat of no judgments. If your lordship feels, my lord, that maybe one slight reference is possible, then otherwise no. But to quickly run through the points, only in reply. Lord, please see the language of section 11.6. And I don't actually request your lordship to read it. I'll just point out.
Yes.
Confined to the existence of confined to the examination of the existence of an arbitration agreement. Lord, now kindly come and have a look at section 8, subsection 1. It ends with, my lord, unless it finds prima facie no valid arbitration agreement exists. So, my lord, there's a difference. 8.1 refers to a valid arbitration agreement. So, my lord, while deciding a section 8 application, your lordship will also look at validity. Now, my lord, also see, my lord, section 45. second last, last part of the section, that the said agreement is, unless it prima facie finds that the said agreement is null and void, inoperative, or incapable of being performed. So 8 and 45 go beyond existence. They look at validity of an arbitration agreement. That's so there, my lord, is the difference between an adjudication.
But after the 5-judge bench of in Global,
Yes.
that has been a bit relaxed. I mean,
Yes, it is relaxed. It is relaxed. I'm not saying that your lordship cannot see. If, my lord, ex facie your lordship finds, then of course, in a given case, your lordship may see it. Now, my lord, to come to the agreement, I'll quickly run through, my lord.
I'll request both of you to file very short notes of
Yes,
arguments,
yes, yes. We'll do that.
just to jot down the points.
Now, my lord, I'll quickly run through, my lord, agreements. Please take part 1.
But don't restart the hearing, sir.
I'm sorry, my lord.
Don't restart the hearing.
No, 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 no.
Then
not
the
at all.
purpose of the Saturday hearing will be frustrated.
No, no, no.
Yes.
Sorry, my lord, instead of taking it up in the second call, because I really don't think I'll be able to come back. My lord, can it be taken up on Monday?
Keep somebody, Mr. Mitra, when the matter is called on. Let that prayer be renewed. I'll definitely consider.
No, just 2 minutes on each document. Page 16. This is a partnership deed.
Yes.
Lord, there's a type copy which, my lord, comes later
Mhm.
at page 20, capital A.
Right.
Paragraph 4, my lord. Business. This is a partnership firm. The business of the firm was to run a private kindergarten junior school. So, my lord, the firm runs the junior school, the kindergarten, the high school, the junior college, and higher educational colleges.
Hmm.
Subsequently, my lord, page 24.
But parties may add new lines of business also
Yes,
under any name and style. So it was very fluid.
yes, yes, yes.
Very well.
Then, my lord, I'll just indicate how it's flowed. Then, my lord, page 24. Same.
Hmm.
Swarna School, page 24, second paragraph. Swarna School in business of running junior and high school under the name of Swarna School in co-partnership with each other.
Junior college and higher educational colleges get deleted.
Yes.
All right. Very
I
well.
think the dream ran out, my lord, at that
I think
point.
so. Yes.
Now, my lord, kindly see page 34. This is the trust deed.
Hmm.
Trust comes subsequently,
Hmm.
only in 98. Now, by this trust deed,
Hmm.
my lordship will please come straight to page 40, 40 at the bottom, just for the continuation.
Hmm.
Whereas the settlers are desirous of establishing a public charitable trust for the purpose of educating and training young boys and girls in educative pursuits, and for, now to 42,
Hmm.
that purpose, to hand over the secondary section of the educational institution, consisting of classes 5 onwards, to the trust. And, Lord, 2 very important clauses. 44.
Yes.
My lord, this is the business of running, my lord, the school is secondary school is the trust property. And at 45 is very important, because this is how trustees are to be, my lord, appointed. Not less than 3, my lord. 4A, not less than 3, not more than 5. And B, trustees for the time being will be at liberty to appoint by unanimous consent additional trustees or trustees within the number mentioned above, for which period or such terms, etc., etc. And, my lord, then powers of trustees are there.
Hmm.
And lastly, my lord, page 47, J,
Hmm.
constituted attorneys can be appointed for carrying out the purpose of the trust. That's, my lord, enough with the trustees. There's a trust deed. There's a further deed of partnership, 52. Lord, the situation is this: after the trust deed is formed, below 5 is under the partnership firm, above 5 is, my lord, under the trust. Now, my lord, the further deeds of partnership, let's not disturb your lordship. Then there's a supplementary trust deed, my lord, at page 61. And now, my lord, kindly come to the agreement where I finish. Page 87.
Page 90, 87. it starts.
87, my lord. At page 89, where the recitals start. Lord, please omit the first two recitals, the third one on the top of the page, whereas the school is run by the partnership firm from class 1 to 4 and by the trust from class 5 onwards, whereas the partnership firm is a tenant. Then whereas parties first and second part have decided to exit from the educational profession, whereas party of third part in its ambition to pursue the expansion of its existing business considered proposal of the party of the first and second part to take over control of Swarna School, and all the parties have come to an understanding whereby the party of first and second part shall transfer the entire partnership business and the trust in favor of the party of the first part. And then, my lord, one at the bottom, objective is take over entire business of the partnership firm. And on the next page, 2.1, 100% management control of the firm and trust to be handed over. And third party shall acquire complete management control, right, title, and interest. Now, my lord, then there's the arbitration clause at 97. Lord,
And specifically assigned tenancy also.
yes,
Next page.
a few, my lord, propositions of law, which I'm not going to cite judgments, which are, my lord, established. Whether they apply to my case or not is debatable, and the debate could go either way. Number one, I'll deal with the trust. Trustee of a public trust, where the trust deed permits appointment of any person of their choice, can appoint any person, which can also be me, to take over the management and control of the trust. If the trust deed did not permit, it would have been a different matter. I am entitled to go and show that here, my lord, I am not trying to establish, my lord, my rights. I am only trying to establish that I have a right to speak.
What is your exact dispute? You are not being permitted to do so.
They've taken money and they are not, my lord, handing over control.
Regarding the entire partnership as well as the trust.
Yes. So, my lord, trust deed permits an attorney to be appointed who can do everything which the trustee does, and B, any other person can be appointed as trustee. A trustee enters into a private contract for the purpose of appointing A or B as a trustee. It's a debatable question, my lord. And I'm saying debatable because I'm not, my lord, trying to say that it's 100% this way or that way.
If it's debatable, it has to go to the arbitrator naturally. That will be the line of argument.
That's the line of argument.
Obviously.
It's debatable whether I have a right to be appointed as a trustee or as an attorney, and whether you are stopped from saying, no, I will not, because you've accepted money and you've been sleeping over it for some time. Proposition 1, for this there's nothing void in it. I can go before the arbitrator. He can say it's void. That's an argument before the arbitrator. I can lead evidence. Number 2, a public trust is also entitled to alienate its property in the event of legal necessity.
Yes.
Alienation is not void. For the alienee in a suit to invalidate the transfer can come and show legal necessity.
So you can go before the arbitrator and prove that it is for legal necessity.
Yes. Whether it stems from the agreement, whether it's open to me. It may be a good case, bad case, but I can argue this.
All right.
Number 3, regardless of public trust, there is nothing to stop class 0 to class 5 to be given to me, which remains under the control of the partnership firm and has nothing to do with the trust.
That probably you cannot segregate like that. The dispute has been raised regarding the entire transfer.
Yes, so part of it can go to arbitration.
If part of it can go and part cannot, then
Then the whole thing has to go for the arbitrator to
or the
decide.
other way around.
So then, because if your lordship today, I'm assuming a situation where your lordship decides against me completely. Effect of that judgment is I will never have a right to argue that this agreement is not void. On a Section 11 application with its constricted scope, my rights will be closed forever and he'll be sitting on my money forever.
Not forever when the suit ends.
Suit, my lord, if it's void, then it's void. I can't really proceed in a suit also.
Very well. Very well. Right.
If it's void, I can't, my lord, proceed in a suit for
Cannot be
it.
conclusive, Mr. Chaudhary. In
Section-
Section
no.
11 definitely can't be conclusive.
Section 11 for a decision that it's void will be definitely res judicata between the parties. It's a judicial authority now deciding. Because if your lordship is leaving the confined restriction behind,
Very well.
that is the problem. So partnership disputes, I can anyway go. And these are, my lord, arguable propositions. And now, my lord, 11.6 scope. 11.6 scope is, if my learned friend has placed the judgment, your lordship has read the judgment. It has to be 100% waterproof, evident to your lordship, and your lordship has to be satisfied that there is no argument which can be raised. Even with a 1% chance, I get to go before the learned arbitrator for the purpose of an argument.
Very well. Yes.
This is- And on the certified copy, my lord, we have, my lord, agreed no affidavits with certain leeways to expedite hearing of a matter.
That's
If he had-
different. But
Yes, but if he had taken the point in his opposition that there's no certified copy, this is the objection. In my reply, I can file a certified copy and I have undertaken to do so. So if your lordship, my lord, and it will be in view of my undertaking, your lordship can call upon me to file it and then decide against me. There's no,
affidavits were not directed in this
No.
matter as yet. Yes.
we argued first day
Very well.
with if
That
I-
scope remains. You see.
Yes, so this is our, my lord, way of doing it quick.
Do you have the certified copy with you?
My lord, certification is to be done by me. My client will sign it and file it.
Very well.
That's how certified copies are prepared in every matter.
Very
I have to certify that it's a correct copy. And in any case, are cases that the original is with my learned friend. So there's an exception also.
All right.
So even if your lordship is to decide against me, but to finish the point, your lordship can use my undertaking to say, file it, I'll hold against you. There's no problem. And I can
Can
file
be
it.
made subject to filing also.
Yes.
The order can take effect
Yes.
if at all.
If at all. If-
Right. So put this in a short written notes.
I'll do that.
Yes.
I'm grateful, my lord.
Your lordship,
Just
I'll
one line arguments, just not elaborate
One
arguments.
page.
Thank you.
your lordship-
One page. And in normal font.
What will be the space?
No, that will be
The page will be what size?
chart paper.
Yes.
Your lordship, I'll just take 2 minutes to just respond to the
Please,
questions
yes.
which have been said. Let's start with this suddenly point of certified copies. There is nothing in the averments which say that the document is with me. It is our case that document was never with us. There is
Not
nothing
yet,
in their
yes.
averment which says that they cannot rely on the exception to section otherwise. And the next thing is, with regard to certified copies, your lordship, we have shown a judgment which is related to section 8, but shown a judgment on a similar provision that you cannot improve upon your case. And specifically in light of the scheme rule 7, that if there is a technical defect, then the only course of action is to dismiss it and let them have to file again. And your lordship has seen that in the NN Global judgment itself, that original copy and or certified copy has found place in the conclusions itself. That it says that it is mandatory. Now, the other point which has been raised with respect to section 8, 11, and 45 having different connotations. Your Lordship, I already placed that paragraph which says it cannot be in Vidya Drolia as well as in NN Global, that it has to be read in consonants, and the mandate of section 8 and 11 are the same. So it cannot mean that existence of a contract would mean something else other than validity of that other than a valid contract. This already has been decided. Now, different facets of firm and trust that is there. I can't say anything else. Now, the question with regard to a public, not a public trust, Your Lordship. It's a public charitable trust. And I have shown the judgments here, which is it says it's a mandatory. It's not a question of arguable, debatable case at all. If there is a question of any kind of transfer with regard to necessity or otherwise of any kind of property of a public charitable trust, then permission of a court is required.
Mr. Sinha, if there is no legal necessity at all, suppose, finally it's concluded by the court also, no legal necessity. Can the court, when parties approach, grant that liberty to transfer?
No, Your Lordship.
It cannot.
It cannot. It cannot.
So if that be so, then your argument gets justified, because that has to be thrashed out before a court of law.
Even otherwise, Your
I mean, one of the justifications.
even otherwise, supposing there is legal necessity, presuming there is legal necessity also. Even
If there is legal necessity.
if there is legal necessity also, then also it is only the court which says, certifies, yes, this I recognize as a legal necessity, then only you can sell.
Right.
Otherwise, so there is no question of debatable or otherwise. And the other one point which has been made with regard to segregation, Your Lordship indicate, that will fall squarely with the mischief which was tried to be contained under Sukanya Holdings, that you cannot bifurcate the cause of action. It's the same thing. And Your Lordship, I already showed there is, because we have not used, but I have relied upon their own petition, that part of the claims are in rem in my suit. How can it be referred to arbitration? Well, because then that part of the claim will be decided has to be decided with the civil court. These are, Your Lordship, my submissions. On Monday, I will submit notes.
That I'll also come on Monday in
Well,
that case.
The hearing is concluded.
Your Lordship, this is one thing I just wanted to add. I'll supply him a case judgment, which
No judgment, no further judgment.
because there is one thing, because Your Lordship indicated two important things.
So I precluded Mr. Chaudhary from citing.
Very well, I will not. Then, because Your Lordship had
Improper.
asked me with regard to the exception under section 49.
But
which
if
there
my
today-
learned friend wants to cite all judgments within his knowledge, no hearing can end. His knowledge is too vast.
Your Lordship, not that. But Your Lordship, my learned friend.
No,
was
Mr.
not
Sinha, you will decide whether that's a compliment or a.
We'll discuss it during lunch.
No, section-
লাইনটা শেষ করি না।
হ্যাঁ।
Hearing is concluded. Full stop. The parties shall file their written notes of arguments on May 8, 2023, when the matter shall next be listed for such purpose.
And ঝামেলা করি।
Yes, what were you saying?
Your Lordship, section 49 on
না,
the,
যেটা আছে সেটা আমি থাক, আমি play করি।
they had taken the point of an exception in section 49.
Yes.
And Your Lordship had asked me to look into it. That's what I wanted to indicate. That Your Lordship, the judgments on that, on the exception of with regard to a specific performance, a suit for specific performance, it says that it can be used only to prove a oral agreement. Only to prove an oral agreement. That is, it is not a written agreement that can be proved. Oral agreement. Now, if that is so, the oral agreement is with regard to an arbitration. NN Global says you cannot have. You have to
Oral
have
evidence, if it's oral agreement, then it becomes collateral. But if
Oral
you rely on that agreement
Collateral or specific
or
performance.
specific.
Your Lordship, well,
Sir, all this
my argument.
Well, I
is-
wish I do a suit before your lordship against my learned friend,
I don't.
where
wish
all
that.
this will be
I
decided.
don't wish that. I don't want all my salaries to. Thank
Very much on this.
Grateful. তোমার নরমাল লিডিং থাকবে জাস্ট এটা। নিচের দিকে যাবে তাহলে তুমি মেনশন দিয়ে দেবে। ফটো থাকবে 4-5 তো থাকে আমার। পার্ট না, নতুন যদি ফাইল হবে
পিটিশনটা।
হ্যাঁ, তুমি মেনশনটাই থাক, তুমি মেনশনটাই থাক।
To be mentioned.
Item number 2,
Yes,
I'm
SAPC Limited versus Hindustan Copper.
appealing for the petitioner.
right. You are for the respondent?
Respondent.
Any objection to arbitration?
My lord, we don't have any formal objections, my lord. My lord, I just wanted to point out two things in this proceeding, my lord.
So that you can answer. It will be easier. Yes.
My lord, firstly, my lord, as per the terms of agreement of the arbitration, the parties have agreed to 3 arbitrators. But my lord, in this petition, my lord, my learned friend is seeking for only a sole arbitrator to be appointed.
If there is
by
no
this court.
agreement, that can be done.
So, but,
11, it
but-
can be done.
But my lord,
Composite reading of 4, 5, 6.
but my lord, we are not accepting the arbitrator appointed by them.
Obviously not.
Yes, so my lord. can
Obviously
appoint-
not.
That is why the section 11 application is.
So my lord.
Yes,
can-
exactly. So 11.6 chart gives the charter to the court
Hmm.
to appoint a
Yes, ma'am.
single arbitrator also.
My lord can
So
then,
that can be done. I mean, it's not impossible under the law.
but my lord, if my lord pleases to for a single arbitrator.
Just see, yes. And what is the other objection?
My lord, this is the only
This
arbitration.
only. Yes, show me the arbitration clause,
My
please.
It's page number,
My lord, kindly sees page 29. Page 29, my lord, clause 16.
All right. And what is the dispute?
My lord, this is with regard to my lord, mining of ore from the mines and my lord, conversion of the ore into copper concentrate, which was to be done at Ghatshila, Jharkhand. My lord, previously, the present work order was issued to one IRL Limited, which they had failed. Subsequently, it was given to the petitioner, my lord. My lord, we had carried out all the works. There were certain terms and conditions which were to be complied by, which was a condition precedent on the part of the respondent to oblige, which they failed to do. Specifically, the claim, my lord, I'll just mention about the claim. My lord, the claim will be with regard to the damages that have been caused and the
Falls within the
my lord,
clause. Yes. Very well. What is the valuation approximate? I mean,
my lord,
what should be the-
my lord, the claim will be around 4.71 crores, my lord.
he will be an ex-judge. He or she will be an ex-judge of the
My-
High Court.
Grateful.
Learned counsel for the petitioner places reliance on clause 16 of the
It is the
work order
my lord, page
dated
24.
July 6, 2017, and submits that the dispute which has arisen between the parties now falls squarely within the scope of such arbitration clause. For next para, the dispute is also arguable, comma, it is submitted. For next para, learned counsel appearing for the respondent submits that originally there was an agreement between the parties to appoint 3 arbitrators, comma, 1 by each party and the third by the 2 arbitrators appointed. However, comma, now the petitioner has sought for appointment of a single arbitrator. Next para, that apart, comma, needless to say, comma, the respondent also disputes the merits, the issues raised by the petitioner on merits. Next para, upon considering the submissions of learned counsel, comma, it is evident that the dispute which has arisen falls squarely within the scope of clause 16 of the work order dated 7/6/2017,
My
and the issue.
my lord, it should be 6th of July 2017. 6/7/2017.
What did I say?
My lord, 7/6/2017.
Oh, I'm sorry. July 6. July 6, 2017. And the issue in question is undoubtedly arbitrable. First up, as regards the objection raised by the respondent regarding the number of arbitrators, comma, the scope of section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 gives the charter to the court, comma, hearing an application under the said provision, comma, to appoint even a sole arbitrator if the agreed procedure between the parties has failed with regard to arbitration. First up, hence, comma, AP number 163 of 2023 is allowed, comma, thereby appointing Justice Topon Kumar Dutt, a former judge of this court, as the sole arbitrator to resolve the disputes between the parties, subject to obtaining his consent stroke declaration under Section 12 of the 1996 Act.
Great.
My lord, just one more.
Okay.
Since we are not filing any affidavits, my lord, that can be.
Section 11.
My lord, still, my lord, because there are some factual issues which, my lord, are written.
If you love that phrase, I'll put it there. Since affidavits have not been invited, it is deemed that none of the allegations made in the application under Section 11 are admitted by the respondent.
I'm grateful. Great.
Pass over matter item number 3,
Yes.
Solai Malai.
Not today, till Monday.
Since I'm here, my lord, I was supposed to go to Rajarhat, my lord, maybe they'll
Rajarhat?
for a matter. So I thought, my lord, I'd rush.
Still on that matter.
They're supposed to ring me to go, my lord, but
Very
since they haven't, my lord, let's keep
Would you like to start or start on Monday? Whatever you like.
it on Monday.
The other side may be in difficulty.
Yes, they are, my lord.
Naturally.
No, no, I understand.
I'll keep it on Monday or tomorrow. Whenever.
My lord, kindly keep it on Monday. Tomorrow there might be a bit of a. There's another hearing matter fixed for.
Oh, what's it? I thought some other.
No,
On the prayer of learned counsel for the parties, the matter is adjourned till May 8, 2023.
I'm sorry, my lord, to cause your lordship the trouble.
No,
but
not at all, Mr.
Very great.
No problems.
Very great.
Audience said, appellate side. Now the appellate side matters. Yes. অরিত্র মোশনে যদি কেউ না থাকে এখন ফার্স্ট কলে পাস ওভার দেব মোশনটা শেষ হলে হোল্ডের আগে আবার সেকেন্ড
Appellate side, new motion. Item number 1.
yes please for the other side you're appeal very
I
yes.
don't know what I'm for the petition in this matter. My lord, this is with regard to my lord. My pair was to remove the electric water line, my lord, which is drawn over my landed property. Now, my lord, in last.
High tension or low tension?
Low
Not for you regarding the power.
Residential premises, my lord, low tension line. My lord, what is happened, my lord, this property belongs to me. And the property, my lord, through which, over which, my lord, the line was drawn, my lord, it is classified as a, my lord, jol, my lord, this is a water body. My lord, the recorded is there. My lord, my pair is.
Dr. Sarah, did you have an inspection?
There is an inspection and the inspection report has already been filed. Today, the date has been fixed to take instruction on the inspection report filed by me, Lordship.
My lord, what is happened, my lord, they, my lord.
What does it say?
We should
Does
my
it cover his property?
It doesn't say that, but say that we can shift the meter. What happened in Lordship? There is an overhead line. There was no objection at that point of time. There was no house.
Subsequently, they want.
Subsequently, they won now. Now, at this stage, your lordship was pleased to direct me, the electricity authority, to make an inspections to see whether it can be transferred subject to technical feasibility. It can be shifted or not. On that basis, inspection has been carried out by giving notice to the petitioner as well as to the private respondent.
Yes.
On that pretest, it has been held that it can be shifted as the estimated cost has to be given in pursuance to your lordship direction. And that cost has also been given. Now I don't know whether they intend to pay that amount or not.
So this will be shifted beyond their premises.
Yes, beyond that.
Yes.
My lord, what is happened, my lord, they issue the quotation of 28,000. My lord, who is, my lord, these, my lord, there is a 2 line. My lord, for the.
Mr. Bhattacharya, in jurisdiction, I cannot decide the amount of money which will be required.
My lord.
That will be going too far, and 28,000 is not
My
exorbitant.
client is not able to, my lord, pay the said amount, my lord.
That's a different proposition. Under the law, you have to pay because you are not seeking a shifting in the.
My lord, I want to remove the, my lord. I want to remove, my lord, because of that, the line drawn over my landed property.
Then I'll have to reject. If you say you can't pay, then I'll have to record that and reject.
If your lordship, my lord, because of the cost.
So I have understood the because.
Cost.
28,000, I cannot reduce it sitting here in
Cost, my lord,
20.
shall be bear by both the two parties, my lord, the private respondent who has enjoying the electricity, my lord.
You are not wanting shifting.
Well, I am wanting to remove it, my lord.
If you want to remove it, then you have to pay. That's the law. I can't improve that.
my lord,
For an individual, the law cannot be changed.
my lord, you will also kindly, there is a two line,
8,000 is not in lakhs.
my lord, that was not, my lord.
But that much cost
the
will
payment-
be
my lord,
enough, Mr. Bhattacharya. Let us not repeat and on the same thing.
may I just
Learned
part-
counsel for the
Pattern-
petitioner. Please let me pass my order now. Learned counsel for the petitioner submits that the petitioner does not have the financial means to pay the quotation raised by the WBSCDCL for shifting the electricity line. Full stop, next para. It appears from the inspection report filed by the WBSCDCL that a quotation amount of rupees 28,265 has been raised for the purpose of shifting the electricity connection as per the request of the petitioner from the petitioner's property. Full stop, next para. It is well settled that the law is well settled that in the event the petitioner seeks to have the overhead line removed to a different portion of his own premises or to a different level in the same premises, the costs may not have to be borne by the petitioner. Full stop. However, since the petitioner is seeking a shifting in the present case to a different property altogether, the costs are to be borne by the petitioner. Full stop. Next para. Since the petitioner submits that the petitioner is not agreeable to pay such shifting charges, the petitioner's prayer for shifting cannot be allowed. Full stop. Accordingly, WPA 8277 of 2023 is dismissed without any orders to cost. Urgent Xerox certified copies. Full stop. Acta line should add korda. In the event the petitioner, within a fortnight from date, decides to gather such amount and pay the money, it will be open to the petitioner to apply afresh before the WBSCDCL for such transfer. And if the fresh application is made within a fortnight from date, the WBSCDCL shall consider the same and take necessary steps accordingly.
Deeply obliged. My deeply obliged.
Item 2,
For the petition, my lord.
Yes, please.
For the distribution company.
Yes, Mr. Kutubuddin, what is your matter?
My lord, last two questions, lordship directed.
All
My lord,
served. All served.
I have received, my lord.
Yes, what is the problem in giving connection?
No problem.
No problem as first. These are the things. The inspection report is.
These things have to be done. You have got a copy of this?
My lord, I have.
Do these things and
My
dispose
lord,
of the
my
petition?
lord.
Learned counsel for the WBSCDCL hands over a written instruction dated May 2, 2023, indicating the steps which are required to be taken by the petitioner to get a new electricity connection at his premises. Full stop, next para. A copy of the said communication is also handed over to learned counsel for the petitioner. Full stop. It is submitted on behalf of the petitioner that the latter is agreeable to comply with such conditions. Full stop. Accordingly, WPA 9141 of 2023 is disposed of by directing the petitioner to comply with the formalities as indicated in the communication dated May 2, 2023, as well as all other required formalities in law at the earliest. Full stop. You have already applied for that connection.
My lord.
Full stop. Upon completion of such formalities, the WBSCDCL shall give the new connection to the petitioner within a fortnight from the date of such compliance.
Grateful.
No rest to cause urgent certificate. Thank you.
Grateful, man.
Great.
একটা কোথাও লিখে দিই অনিন্দিতা একটা কোথাও লিখে দিই it is kept on record. The instructions filed today be kept on record. Thank you.
Item 3,
Yes.
I pray for leave to file, my lord, affidavit of service.
Sir.
My lord, here in this case, my lord.
All have been served, Mr. Dey?
Yes.
I am for applying.
My lord, father of the petition was the domestic consumer of the electricity, my lord, who died in the month of February 2014. Immediately the mother Sean, who is the user, made representation before the authority concerned that his father had died and new connection to be transferred in his name. That has not been done. Electric bill is sending in the name of dead person, but that I have paid. What is problem has been propped up, my lord, when in the year 2011, 18, my lord, January, my lord, meter, my lord, since the meter has been defective, my lord, I made the application by the authority, meter should be changed. When the meter has been installed, thereafter, my lord, the huge bill are sending. My lord, again.
When did your father die?
2014, my lord, died on, my lord, 7th day of February 2014.
14.
Well, intimated, my lord, 12th December 2014. Which
So what is your grievance now?
Grievance
Huge
is
bills
this-
for that period? You
My-
did not pay that. Father did not pay that.
No, my lord. What has happened, my lord? My lord, here, last page 25 NFC P10. My lord, according to my lord, that old meter,
Hmm.
my lord, which is defective, my lord, huge bill has been sent.
It was replaced.
No, replace that also defective.
Oh, this is your usual research.
My lord, defective,
Now I've
my lord,
got it.
my lord, page 20, page 20. Meter card, page 20.
Yes.
20. My lord, kindly see, no such my reading, my lord, here, my lord, noted in the meter card. My lord, in the year 2019, my lord, the average basis
Did you
electric.
raise this billing dispute at any point of time?
No, my lord, what is happening in this case? Line has been
After they're asking for that money, you have grown wiser.
not that matter. What is happening in this case? But 2019 bill has been sent. There are no bill has been sent. But the authority said that your meter has been locked. So no bill has been sent. In the 28th day of February, line has been disconnected without service of notice under section 56 of the Electricity Act. But section 56 there is provision. When the electricity board.
15 clear days.
56. 15 cleared the notice.
Yes.
I may deposit or may not.
You say no notice was given to you.
No notice has been given. But what has happened? 2 years already elapsed. Number one. Number two, my lord, here, my lord, no notice has been sent. Without service of notice, my lord, that line has been disconnected on 28th of February 2023. Well, at present, my lord,
2 years elapsed. They did not show it in their subsequent bills. For
no, my lord, because they said the your my lord, connection has been locked. My lord, what is happening at present, my lord? My lord, line
locked
has
by you must be. Meter locked by you.
No, not that.
Locked means meter locked means the meter room is locked or the meter is
No,
locked.
not that. My lord, the consumer number has been locked by the authority.
Why?
I don't know, my lord, because they have not sent the bill.
You did not take out any grievance before any authority. Since when was it locked?
My lord, that authority has said again and
Since
again.
when they started saying?
My lord, after 2019, no bill has been sent.
You merely did not pay.
My lord, at present.
You ask for the bills.
My lord, what is happening at present, my lord? Presently, my lord, new meter has been installed. Now, my lord, meet the last, my lord, reading is showing, my lord, 2771 units. My lord, for 4 and 6 months.
We don't know what you are consuming there, Vishwati. How can we?
My lord, what has happened, my lord?
Even then, it's a billing dispute. Did you raise it before the grievance redressal officer?
My lord, problem is this, my lord, the original consumer had died. I intimated, let them change the electric line in my favor. They did not change.
They did change. You said that they changed.
Yes, my lord.
They changed. After that, you are saying again defective.
Again defective.
This time also, if they'll change again, it will be defective, Mr. Whenever the payment time comes.
No, not that, my lord.
That's a general issue. I mean, it will become defective whenever they replace. So let us not think about those things.
My lord,
Let the defect be, they'll charge amount.
My lord, I have wrote one judgment of this honorable court. My lord, without service of notice 56.
Yes, service of notice is
my lord, yes, my lord.
That's a good.
My lord, the head note, my lord, first, my lord, it is my lord, para 19. A division bench judgment.
After 2 years, yes, 56(2) is there.
Yes, my lord.
Depends on the facts of the case.
My lord, since my lord, 2019, my lord, last bill has been sent. 2 years already been lapsed. So my lord, it is not binding. But this is their fault. Well, they, because they have not sent any bill.
You have been enjoying electricity during that period.
Yes,
When was it disconnected last?
28th day of February 2023.
Let
My
me
lord,
hear.
my old mother man is living a heart patient. In the, my lord,
Very,
it's my lord, time, my lord, domestic connection. my lord.
very, yes. Take your seat, Mr. Dey. I'll just
So
say.
one thing, my lord, I have only one respect to
Another
submission.
judgment.
No, not judgment, my lord, here. My lord, here, one notice has come in the name of the petitioner. My lord, for payment of waiver scheme.
You remembered this suddenly.
No, not that. Because, my lord, here in this case, my lord, here it is directed, my lord, to pay but 30th November 2022. But notice has come in the month of December. After 1 month. So they have now received
It was signed in December itself.
December, but it has come December. They sent December.
Right, understand.
It is directed by 30th November 2022.
No, within 2 years, they say total dues as on 31st of December, such and such. They've written there, the first A, clause A.
My lord, here in this case, my lord,
That is the breakup. B2A for the breakups. That is the breakup.
yes.
A is the claim. As on 31st December, since November to 2 years have not elapsed. So comes within 56(2).
My lord, because 2 years already left.
May I, Lordship, kindly?
Very well, yes. Oh, yes, right.
May I,
You're right.
Lordship, kindly?
You're right.
But there are basically, as I have understood that there are threefold of submission. First, the meter is lying in the name of a dead person that has not been transferred in the name of the petitioner. Second submission is that it is a defective meter that has not been replaced. And the third submission is that it is barred by limitations and without notice, the line has been disconnected. So on these three lines, may I submit to the first point that if your Lordship kindly see the paragraph 1 of this writ petition. That there are also other, paragraph 2, I stand correct, paragraph 2, that the
3 years.
original consumer died and there are 3 years. And if your Lordship kindly, probably your Lordship had read the regulation 46.
Yes.
Sorry, I am handing, I thought that Lordship has.
No, I have. You have given. Your officer has.
Yes. Regulation 46. That is on 31st May 2010.
Yes. Which clause?
I will draw your Lordship kind attention to clause 7.
Yes.
Lordship got that? In the clause 7, your Lordship kindly see the heading connection through transfer of service meter in case of change of ownership, occupancy of any or purpose only. Now here, your Lordship will find that in case of change of name, either in case of a dead person or the existing consumer, if it is the existing consumer, then no objection is necessary from the existing consumer. And if he is a dead person, if your Lordship kindly see the 7.2b, succession certificate or undertaking through affidavit as a legal heir of the original and entitled to get such service meter as a successor in case of demise of the original consumer. In case the number of legal heirs is more than 1, the no objection certificate by other legal heirs through affidavit in favor of the applicant legal as the format in annex 8 is to be given. Nothing has been given. It is nothing is on record. So since there is a specific provisions.
That is the first point.
First point.
Next.
So far the second point is concerned. So far the defective meter is concerned. Nothing is on record that they have made any objections or they have made any application before the concerned authority. That is the GRO. Nothing is on record. So far this defective meter, that is to be the point is to be raised before the concerned GRO. That has not been made. So far the third point is concerned. This is a very vital issue where my learned friend says the 2018 due has been raised after a period of 2 years. Naturally, there is a burden fit, it is true. Now, there is a waiver scheme which has been declared by the government. Now, if your lordship kindly see the application itself, where it has with reference to your application, my learned friend has made an application which has been specifically suppressed in this writ petition, where he has agreed in the waiver scheme in the year 2022 to pay that amount, because in the waiver scheme 50% amount is to be waived and the 50% amount is to be given. If your lordship kindly the provision here, the amount which has been laid down, here 50% amount has been waived. Now, on the pretext of his application in the year 2022, and your lordship know under subsection 3 of section 25 of the Contract Act, if there is even there is a limitation that can be revived if he chooses to make that payment. If your lordship kindly see, may I? Lordship got the Contract Act.
No, read out for me.
I will hand it over.
Yes.
Lordship knows that the 20.
Even then read out for me.
Yes,
Yes.
that it is a promise
This
made.
section
25, subsection 3 of section 25.
Right.
That is the no consideration, no contract, the exception to that provision. Subsection 3, it is a promise made in writing and signed by the person to be charged therewith or by his agent. Now he is declaring to be the agent, generally or specifically authorized in that way to pay wholly or in part debt of which creditor might have enforced payment, but for the law of limitation of suit. So on that basis, in any case, such is agreement is a contract. Now my humble submission.
I'll just want to go through the.
Thereafter,
Yes.
you,
Yes.
suppose any claim is barred by limitations, and if the person against whom there is a debt and that person specified that he is willing to pay that amount, he has made an application in the year 2022 that he is eager to pay that amount, but instead of doing that, he sat tight over the matter. But this is the application. If your lordship kindly see, may I hand it over to your lordship? But they have made this application. To the chair.
Very good. Yes.
But and next, your lordship, the notice. If your lordship kindly turn
Application for getting the benefit of the waiver.
benefit of the waiver, that has been made in the year 2022. Yeah.
Get it? Yes.
And your lordship kindly see,
Hmm.
thereafter, after making this application, he sat tight over this matter, never made payment. We have raised that application one after first application. If your lordship kindly see, on say 11/11/2022, we have raised the bill on the basis of their application. If your lordship kindly see, with reference to your application, lordship got that. Subsequently, again, that has been handed by my learned friend. That is on December, we have again raised that since there is a waiver scheme, you make payment. That has not been done. Subsequently, if your lordship kindly turn to the next page,
Next
that
page
is
of-
the notice
Next page of what?
which I have handed over to your lordship.
Ah.
I'm sorry that.
No. Yes. Then
Your lordship find that notice.
Hmm.
Notice dated 17/1/2023. Lordship got that? আমাকে একটু দিন নাম দিন। Next page 17/1 that is a notice under 56/1.
this. Show me your copy.
Yes, this
From
one,
there?
This one.
Yes.
This is the notice. Demand has been raised on 17/1/2023. Kindly see the date. That is in 11/11. The demand has been made in December. Further has been made. Then on 17/1 the notice has been given that you make the payment. Otherwise, the disconnection will be made. Lordship got that? Then your lordship kindly see the next page. last part, Mrityunjay Ghosh refused to take that notice. So on that basis, we waited for a 1 month.
Mrityunjay Ghosh is the petitioner.
The father of the petitioner, because the meter is lying in the name of Mrityunjay Ghosh, Your Lordship,
Yes, yes.
and he is the beneficiary. Now, and on that basis, the disconnection took place on 27/2/2023. That is after 15 days. So sufficient time has been given to them to make payment.
Yes, what do you say?
My lord, here in this case,
But
my
that
lord,
has not been.
well, here, my lord, I submitted, I have not intimated. Well, after death, I intimated my father had died, and my lord, to change the electric connection in my name.
Mr. These documents are correct.
Yes, my lord. But here, my lord, section 56 notice, when given, 2023,
One notice.
only last notice to 2023. My lord, kindly see. My lord, date is, my lord, here 17/1/2023.
56.1. 56.1. Disconnection notice has to be given before clear 15
Well,
days from
last-
the disconnection.
My last bill on the year 2019.
Yes, what about the waiver scheme?
My lord,
You agreed.
my lord, what is happening in this case? My lord, since, my lord, they have made here, I have to pay it by 17th November 2023. They have not accepted this bill.
Waiver scheme was entered into before the disconnection.
Yes, my lord, that has not been accepted by the office. That amount waivers, my lord, amount.
No, they gave a letter. You are handing over the
Well,
letter
if your
showing their
lordship-
acceptance.
If your lordship desire to pay that amount, I shall pay immediately. That amount. Under the waiver scheme, here they are doing 24,000.
Why did you suppress that? Your writ petition should be
My
dismissed.
lord,
Mr.
it
Dey.
is, it is, my lord,
Writ petition should be dismissed on that ground
I
only.
have got that copy after the filing the writ petition. It is my problem.
No, not you. Your client has suppressed.
No, my. When, my lord, I called him, please show all the file. Then my lord, I find that this notice has been served.
What is his vocation? What is his occupation?
Occupation is a cultivation.
Yes, what do you say? Dr. Shari, if they pay the amount,
I just leave up to it. But the thing is, there is a suppression, Lordship, kindly.
there is, yes, I'll direct them to pay more. So they will give it.
That I have to from my pocket.
3 objections are taken by the
And your
petition.
Lordship, one thing, subject to Lordship, if they want to change the name, then they have to make the application in a
Yes.
prescribed format.
That's good.
Otherwise,
3 objections have been taken by the petitioner to the disconnection of the petitioner's electricity connection, which is still standing in the name of the petitioner's deceased father. First of next para, the first objection is that the bills, the meter was standing, much after the death of the petitioner's father, the original consumer, in the name of a dead person, despite the petitioner having applied for transfer of name. Full stop next para. Secondly, the meter installed by the WBACDCL, it is contended, was initially defective. Full stop. Upon replacement, the replaced meter was also defective, for which exorbitant charges were raised for a particular period during the lifetime of the petitioner's father. Full stop next para. Thirdly, it is argued that the provisions of section 56 of the Electricity Act 2003 were violated. Full stop. Not only was no notice as contemplated in section 56 within bracket 1 issued, the claim of the WBACDCL is time barred, since the dues alleged are of the period 2018-2019, but the claim was made only in the year 2022. Full stop next para. Learned counsel appearing for the WBACDCL controverts all the contentions. Full stop. It is submitted, by placing reliance on clause 7.2 of regulation number 46 of the WBERC, West Bengal Electricity Regulatory Commission, that if there are several heirs of a deceased person, for the change of ownership, not only a succession certificate or undertaking through affidavit as legal heir has to be furnished, comma, no objection certificates from the other legal heirs are required to be obtained. Full stop. In paragraph number 2 of the writ petition, comma, the petitioner has admitted that there are two other legal heirs. Please take your seat. Two other legal heirs, comma, who have not furnished any affidavit and or no objection certificate as per clause B of subclause B, sorry, as per subclause B, small b of clause 7.2. Full stop. Next para, insofar as the allegation of defective meter is concerned, comma, it is submitted that no such allegation was made by the petitioner's father or, comma, for that matter, comma, the petitioner at any point of time before the competent authority, that is the grievance redressal officer. Full stop. Next para, hence such claim is unsubstantiated. Full stop. As regards issuance of notice, comma, learned counsel for the WBACTCL hands over a copy of a notice under section 56 within bracket 1, comma, after expiry of 15 days from which the disconnection was effected. Full stop. Learned counsel also submits that the petitioner had sought to take the benefit of a waiver scheme floated by the WBACTCL by specifically applying for the same, comma, a copy of which is handed over in court today. Full stop. It is argued that that upon acceptance of such due amount, comma, which was admitted to be payable by the petitioner himself, comma, the provisions of section 25 within bracket 3 of the Indian Contract Act are squarely applicable, and the such contract is a valid contract, comma, which is enforceable in law. Full stop. Hence, comma, the bar of section 56 within bracket 2 was in effect waived, W-I-V-E-D, by the petitioner himself. Full stop. Next para, the documents, comma, copies of which have been handed over today in court by the WBACTCL, comma, are not controverted by the petitioner. Full stop. Learned counsel for the petitioner candidly submits that the the petitioner, comma, who is a cultivator by occupation, comma, was not legally aware and did not hand over the communication made by the WBACTCL prior to filing of the writ, comma, for which such communication dated December 27, 2022 has been handed over in court today. Full stop. Next para. A perusal of the documents handed over by learned counsel for the parties, comma, which are kept on record, comma, indicates that the petitioner undoubtedly sought the benefit of the waiver scheme floated by the WBACTCL, comma, thereby giving a go-by to the limitation period under section 56 within bracket 2 of the Electricity Act, comma, 2003 by entering into a fresh contract, comma, which is valid within the contemplation of section 25 within bracket 3 of the Indian Contract Act. Full stop. Hence, comma, the objection as to limitation is not tenable in the eye of law. Full stop. Moreover, comma, a notice was duly served on the petitioner, comma, a copy of which has also been handed over in court today under section 56 within bracket 1 prior to 15 clear days before disconnection. Full stop. The objection of the petitioner on such score, comma, as such, comma, also fails. Full stop. As regards the alleged defect in the new meter, comma, learned counsel for the WBACTCL is justified in arguing that the said point was never raised by the petitioner before any competent forum at any point of time. Full stop. Next para. As regards the continuance of the meter, comma, till disconnection of supply, comma, in the name of the deceased father of the petitioner, comma, clause 7.2 of regulation 46 of the WBERC is also fully applicable, comma, thereby casting the duty on the applicant to produce the documents as envisaged therein. Full stop. Next para. Although an allegation of suppression of material documents has been raised by the WBACDCL, comma, not without any basis, comma, since now in view of the candid submission of learned counsel for the petitioner and keeping in mind that the petitioner is a cultivator and might not be aware of the nuances of law, comma, such suppression is not taken to be fatal for the writ petition. Full stop. Next para. Since it has been submitted by learned counsel for the petitioner that the petitioner is now agreeable to pay the entire dues, comma, to which the petitioner agreed by way of the waiver scheme, comma, there cannot be any further hindrance in the line in the electricity connection being restored. Full stop. Accordingly, WPA 9661 of 2023 is disposed of by directing the petitioner to deposit the amount payable by the petitioner under the waiver scheme, comma, as claimed by the WBSEDCL in its communication dated December 27, 2022, comma, a copy of which has been handed over in court today. Within how much time?
15 days, my lord.
Within May 20, 2023. Full stop. Next para. Upon such deposit being made by the petitioner and upon compliance of all due formalities, comma, including furnishing documents as envisaged in clause 7.2 of regulation 46 of the WBERC regulations, comma, the WBACTCL shall transfer the name of the petitioner in the in respect of the meter from that of the erstwhile deceased consumer and restore the electricity connection at the said premises. Full stop. No order as to cost. Urgent certificate.
Deeply. I'm grateful to you.
Thank you.
Item 4.
Well, I'm the petitioner.
Yes. You are for the license.
License.
Right. Private respondent. What about service on the private respondent?
My lord, I have served.
Good service.
Yes, my lord, I have served
Very good.
upon all the respondents.
What is the track report?
My lord, track report will not yet come.
How can it be good service then?
My lord, I have served upon all
You have
the
sent, not served.
my lord. My lord, in that event.
In that event, what? Should be dismissed. You said it has been served.
No, my lord,
It is not the correct statement.
my lord, yes, my lord, I am sorry, my lord. It is already served. Now, all the respondents have got it, but the track report from.
Only the track report is not there. The affidavit of service filed today be kept on record. It transpires from the same that no track report has been annexed showing proper service on the private respondent, comma, although the distribution licensee is represented through counsel apart from the petitioner. Full stop. Next para. Hence, comma, to await service on the private respondent, comma, the matter is adjourned and shall next be listed on May 15, 2023, when the petitioner shall file a fresh affidavit of service indicating the fate of service on the private respondent.
My lord.
Only that, only private respondent?
My lord.
But license that also group electric supply, that also made wrong, my lord.
Why?
They has made Contai. Contai is not the supply.
What will be the proper thing? Please tell him. I won't.
Manisda group customer care.
You are the advocate on record.
Yes, my lord.
So please carry out the necessary correction. Arekta line thale add kore dao. Leave is granted to the learned advocate on record for the petitioner to carry out the necessary correction in the cause title of the writ petition to the effect that the appropriate name of the which respondent?
The restaurant number 2, 3, 4.
Of
2,
the-
3, 4.
Of the respondent numbers 2, 3 and 4 be introduced in terms of the submission of learned counsel for the licensee. Please give the details so that do it during the course of the day, please.
Yes, ma'am.
Item 5.
5, please.
I am for the petitioner, my lord.
Petitioner.
Consider that matter, my lord, so where the delay
Yes.
in preferring the appeal under section 127, my lord,
What is the delay approximately?
about 80 days, my lord.
Yes, Mr. Mukherjee.
But there are certain judgments which says that under Article 227, court has no power to condone the delay. Now, my lord, yesterday I took the time to
This is not 227, so not applicable.
26. my lord.
For 6. That's it.
But
Which are the judgments against you, Mr. Mukherjee? Show those.
against my lord, I find two judgment. One is Justice Tandon judgment. Justice Tandon has not considered all these aspects, my lord. But
Very well. Cite your favorable judgments first, then so that we can distinguish.
first judgment, my lord, I'm showing. to the
Obviously, the distinction will be on facts. Names are different. Names of the.
case number. Now, my lord, first of all, my lord,
Why can it not be rectified? I mean,
because my lord, statute says there is a specific provision to prefer an appeal. Now, if your lordship consider one.
it is not couched in negative language.
Yes, but if your lordship consider that this honorable court has put a question that whether if the person who has agreed by the final assessment order is out from challenging the same. Now the question came up, then the answer given that if the person is at all aggrieved by that
If
assessment.
the person was out, that's a different proposition.
No, but
If he was not out, then he's not ousted from filing.
no, then my lord, question came up for consideration that has been discussed in the special bench judgment of our court that if the person has challenged the order under Article 226 within 1 month, now, my lord,
But that is always there.
now, my lord, here, my lord,
Month that is always there, Mr.
here, my lord, he has not challenged the final assessment order.
No, my question is different. Mr. Mukherjee, my question is whether the appellate authority can itself consider the question of consequence.
Subject to.
Show me
first
that.
is- But this is, my lord, 2011.
Take your seat, Mr. Ali.
2011, volume 1, CHN, page 182. Is a division bench judgment, my lord. Now, my lord, if your lordship permit me, my lord, I will read, my lord. এটা 2010, এটা 2011, volume 1, CHN 182. SCC online এও আছে।
You are citing this deliberately.
No, this is the first. I will come one by one, not that. Don't go to the.
Which is a relevant paragraph.
Now, my lord, from paragraph 5. It appears from record that on the allegation of pilferage of electricity, the electricity connection of the.
So writ court, this is a settled proposition, Mr. Mukherjee. Writ court will not interfere if the relief is time barred.
Here, my lord, the relief is.
Relief is time barred.
Now, he.
So writ court won't interfere.
Kindly see his prayer.
That
Now-
can be rectified.
Yes.
Here in a writ petition, 226 jurisdiction, Mr.
But these are all my lord, 220 from 226, my lord.
But that is a settled proposition. No doubt on that. Cite all your judgments.
Now, my lord, second, my lord, I
I
will.
don't require the facts then to distinguish.
Now, my lord, the second.
This is a settled proposition. I agree fully.
The second judgment, my lord, I will show, my lord. This is a single bench judgment, my lord. I don't know.
Even then, binding, unless I differ.
But the question came up, my lord. Initially, first, my lord, the point was taken that, my lord, it is an appealable order. Writ court will not interfere because there is a specific time to prefer an appeal. Ultimately, my lord, when the final hearing came up, now, my lord, the learned advocate for the petitioner says that we could not prefer the appeal. Kindly give us liberty to prefer the appeal. Now, court says no. When there is a specific time, we cannot extend the time. Therefore, my lord, writ petition.
No, I will definitely not extend. Agreed. Writ court cannot extend. That is the principle.
Yes.
Cannot. I agree with that also. Definitely, I have to
Now-
agree. That's settled.
Now, my lord, here in this particular judgment, the honorable single judge, my lord, has extended the time. Not extend the time. The honorable single judge was pleased to permit the petitioner in that writ petition to prefer an appeal, and the delay has to be condoned. The appeal was
Has to be condoned, probably. Anyway, cite that judgment.
said that, my lord, within 2 weeks, appeal should be preferred. Now, my lord, against that appeal preferred.
Do that, I have my doubts whether we have that power.
Now, my lord, the division being presided by Justice Chellur and Justice Bakshi is of the opinion, no. 30 days is binding. Now,
This is the only judgment which hurts him.
no, the ultimately, my Justice Dotto's judgment, I will show that will.
Following this, no, Justice Datta's must be.
But if you lordship consider, my lord, this judgment,
This can be interpreted, yes.
now, my lord,
Person could not challenge, I mean, within 80 days, he's trying to challenge.
60 days.
60.
60 days.
So less than that even.
Now, my lord, the final, I will come, my lord. Now, my lord, another judgment came up for consideration. Now, my lord, an appeal has been preferred. Now, my lord, thereafter, the appellate authority says that as there is a specific time, you have not preferred the appeal, therefore, has been turned down. Challenging the same, a writ petition was filed against the appellate authority order. The writ court says we will know, the High Court cannot interfere. And this is the judgment, my lord. I'm showing to your lordship, my lord. Once. Can you give me 1 minute, friend? Doctor judgment. ওটা কোথায় হলো? এটা না। কালকে বোমা দিয়েছিলাম তো তোকে। এটা না, এটা না। না, 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 গ্রুপে দিয়েছি। But I'm just showing to lordship that has not been printed out, my junior is going. This is the ultimate judgment of the special bench.
Ultimate in the sense of proposition or time?
No, time. Now, my lord, first of all, kindly see, my lord, straight away, my lord, paragraph 2.
Yes.
The judgment. A learned judge of this court was hearing this writ petition. The controversy that enlarged for decision therein was, would an appeal under section 127 of 2003 Act carried from an order of assessment made under section 126 thereof be entertained by the appellate authority if the same were presented beyond the period of limitation prescribed in section 127 itself upon the condonation of delay in its presentation? Or in other words, does the appellate authority acting under section 127 have the power to condone the delay in presentation of a time-barred appeal if sufficient cause therefore was shown? This was the consideration. Now submission was made, my lord, although it is irrelevant, that, my lord, when paragraph 3 last line, my lord, 2 judgment has ultimate conclusion, your lordship will find, my lord, in paragraph, my lord, 43 and 44.
What was that?
44, if your lordship consider, my lord, we are conscious that the delay in preferring an appeal under section 127 within 30 days could result in the person against whom an adverse order under section 126 has been passed being left without the statutory appeal remedy. However, we are also of the opinion that such a person would not find himself totally without any remedy. A final order of assessment under section 126 could be a subject of judicial review if any of the condition for entertainment of the writ petition is satisfied. If indeed the writ petitioner satisfied the writ court that for genuine reason he could not avail the remedy of appeal and seek a writ of certiorari to have the impugned order quashed, the writ court may, in its discretion, entertain the writ petition and judicially review the decision-making process, drawing the inspiration from the constitutional bench decision in the Supreme Court reported in AIR 1961, Supreme Court 1506.
Mr. Mukherjee, the difficulties in none of these judgments, it was answered whether the appellate authority itself has the power to. So your only other judgment which you did not place, that is the probably only judgment.
I'm sorry,
Because none of these judgments say all the judgments are on writ court jurisdiction, either cannot entertain or can entertain depending on the time. Very well.
Now, my lord, here, my lord, he has not challenged the final assessment order. What he has prayed for in the ultimate relief.
No, he will challenge the final assessment order.
In the writ petition, the special.
He wants to. I want to condone the give him liberty to approach the appellate authority.
What is his prayer? I will come, my lord, that judgment I have. found,
Prayer
my
we
lord.
can mold. Prayer, writ petition, Mr. Mukherjee.
No, but the petitioner has challenged the final assessment order dated 10 January 2020 in respect of an unauthorized use of electricity.
I'll have to refer with it.
That
Pardon, Kiram.
I'm trying to lordship. But these are all judgment which I found, and
You are appearing in this matter.
no. Now, my lord, his favored judgment also I brought, my lord, the single bench judgment. To me,
If his client could pay Mr. Mukherjee, he would have appointed you. Why him? He would appoint a rich advocate like you. Not somebody junior like Mr. Ali.
This is the order, my lord.
This is Mr. Mukherjee not in his favor as such. On the facts, that was permitted. This question was never decided. Question was decided only by Justice Mukherjee. Only by Justice Mukherjee,
Yes.
which is against him.
And my lord, kindly see his prayer in the writ petition and the body of the petition, my lord. If you actually permit me to read.
Yes. Which paragraph?
But in the prayer, my lord, first of all, kindly see page 10, a writ of and in the nature of mandamus commanding the respondent number 3 to allow the petitioner to deposit the 50% amount of final assessment bill dated December 29, 2022, amounting rupees such and such only against the complaint lodged at Egra police station under section 135 1B of the electricity act. This can't be, because 135.
Refuse.
Second, my lord, a writ in the nature of mandamus commanding the respondent number 2 to allow the petitioner to prefer an appeal under the provisions of section 127 of Electricity Act 2003, read with amendment act. Therefore, my lord,
Molded.
this is
A is absolutely refusable.
because your
Then
lordship has
you
already
say-
delivered a judgment which has been preferred appeal dismissed regarding 135 and 127. Whether my lord, the both, if somebody has been acquittal, whether he is liable to pay again, my lord.
I passed both ways. So which one was
Subsequent-
rejected? Allowed.
First one in which I appeared.
So I'll pass my order right now. Why keep it pending?
I leave it to Lordship because my lord, only thing the judgment of Justice Mukherjee and my lord,
This
if your lord-
question was not argued, was it? Three
And-
paragraph judgment.
and
six
my-
paragraph.
yes, that is true. And my lord, the judgment of
That was a different question. So much.
appellate authority rejected the section 5 application
Here,
in that judgment. Justice Mukherjee said,
not only on that, here waiver whether it can be waived. That has
can't be, my lord.
that is the decision.
And my lord, another thing, if you lordship see the judgment of Justice Dotto, there it has been said, my lord, last paragraph, just I am reading to your lordship. However, if the writ court is approached long after the final order of the assessment under section 126.
Long after, as in 60 days in his case.
No, December, my lord, April. That is, my lord, 120 more than
December which year? Last year.
yes,
Last December.
2022. And he filed the writ petition. See,
When?
my lord, April 19th April. More than 4 months. 3 months and 3 months and some days, my lord. More than 100 days. No explanation. The explanation is that he went to deposit the amount and we refused. But no question of deposit amount before us, because the 127 says that if
Bengali signature, Mr. Vernacular signature. Not English signature even. Client.
I leave it to your lordship. But my lord, act
If
is-
these people don't get the benefit from court, then
it will be floodgate. It will be open the floodgate, my lord. Kindly visualize that.
no, I'll limit the floodgate. Discretion of the appellate authority, which at least in this matter probably will be exercised in their favor. The short question which has arisen for consideration in the present case is whether a final order of assessment passed by the assessing officer under section 126 of the Electricity Act 2003 can be challenged in an appeal under section 127 of the same act beyond the period of limitation, and comma, if not, comma, whether the appellate court has the discretion to condone the delay in filing such appeal in appropriate cases. Full stop, next para. Learned counsel for the WBACDCL cites several judgments in support of the proposition that such appeal cannot be entertained beyond the period of limitation as stipulated in section 127 of the 2003 Act. Full stop. Learned counsel first places reliance on a division bench judgment of this court reported at 2011 1 CHN 182, নামগুলো দেখে বসিয়ে দিই, comma, where it was observed that a writ court should not, comma, by invoking jurisdiction under Article 226 of the Constitution of India, comma, revive a barred remedy. Full stop. Next para. The next judgment cited on behalf of the WBACDCL is also a division bench judgment of this court, where it was held that this court cannot meddle with the statutory period of limitation provided under the statute by extending the period of limitation, which would amount to rewriting the words of the statute. Full stop. Next para. The third judgment cited on behalf of the WBACDCL is that of a learned single judge of this court reported at 2013 4 Cal LT 486. Full stop. In the said judgment as well, comma, the High Court was of the opinion that the writ court cannot condone the delay in case there is a statutory bar of limitation. Full stop. Next para. Learned counsel for the WBACDCL further cites a judgment of another coordinate bench of this court reported at 2020 SCC Online Cal 3083 to the effect that the provision for deposit and or payment under section 127 within bracket 2 of the 2003 Act for the purpose of the appeal being entertained is a mandatory provision and cannot be relaxed and or waived. Full stop. Next para. A division bench judgment is also cited by learned counsel for the WBACDCL, comma, in his usual fairness, comma, where, however, the division bench was of the opinion that when the remedy of appeal has become time barred, comma, the writ court can grant leave to the consumer to avail the appellate remedy and direct the appellate authority to hear the appeal on merits. Full stop. In another judgment of a different coordinate bench, comma, it was observed by the court that the petitioner therein was permitted to prefer an appeal within 2 weeks from the date of disposal of the writ petition, comma, despite the appeal was time barred by then. Full stop. Next para. As regards the division bench judgments as well as the judgments of the coordinate benches, which say that the writ court cannot condone a delay or entertain cannot condone a delay if the relief itself is otherwise time barred, comma, there is no quarrel with such proposition and the same is too well settled to be upset at this stage. Full stop. Next para. With regard to the judgment of the division bench in Sudipto Kole versus Srimati M. Bhomik and another, comma, where the division bench was of the opinion that the writ court could grant leave to the consumer to avail appellate remedy even after the time bar came into force, comma, with utmost respect, comma, the same did not take into consideration the previous division bench judgment of this court, which held to the contrary. Full stop. Next para. Insofar as the judgment of the coordinate bench, which observed that the petitioner in the said writ petition was permitted to prefer an appeal, comma, the question whether the appellate authority is required to or can go into the question of condonation of delay in preferring appeal was never argued or considered. Full stop. In fact, comma, in the judgment of Murad Ali Mondol Supra, comma, where the learned single judge was pleased to hold that the appeal under section 127 can only be heard upon payment or deposit in terms of provision 127 within bracket 2, comma, did not take into consideration the question which has come up for consideration in the present instance. Full stop. The issue here is whether the appellate authority has the power to condone delay after the expiry of the limitation within the contemplation of section 127. Full stop. The said judgment has not been specifically answered in any of the judgments cited by the WBACDCL. Full stop. Even a cursory perusal of section 127 within bracket 1 shows that the same stipulates that any person aggrieved by the final order made under section 126 may, comma, within 30 days of the said order, comma, prefer an appeal under the said provision. Full stop. Next para. It is to be noted that such restriction of 30 days is not couched in a negative language so as to clearly mandate the operation of the same. Full stop. In view of the provision being one which is extremely restrictive and would tantamount to being draconian, since in such case, comma, even legitimate consumers who are entitled to prefer appeal at a belated stage due to some unforeseeable or unavoidable circumstance will be precluded from preferring the appeal, comma, more importantly, comma, even the appellate authority would be powerless to condone such delay at all. Full stop. Such proposition would border on absurdity and could not have been the legislative intent of section 127 of the 2003 Act. Full stop. Next para. Inasmuch as subsection 2 of section 127 is concerned, comma, however, comma, the same, comma, as opposed to subsection 1, comma, is couched actually in a negative language and reads as follows, colon দিয়ে টুটা কোট করে দেবে, no appeal against an order shall be entertained, তারপর যা শুধু subsection 2টা. Next para. Hence, comma, the coordinate bench in some of the judgments cited by the WPACDCL, comma, rightly observed that the provision for deposit of 50% is mandatory and cannot be waived. Full stop. Next para. Thus, comma, there is no question or necessity for distinguishing the judgment of the learned single judge in Murad Ali Mondal Supra. Full stop. Next para. However, comma, in the light of the above discussions, comma, the stipulation or time bar of 30 days within the contemplation of section 127 within bracket 1 of the 2003 Act is directory and not mandatory. Full stop. As such, comma, it is open and within the discretion of the appellate authority, comma, upon appropriate cause being shown by the appellant, comma, to consider the condonation of the delay, comma, if reasonable, comma, for the preference of the appeal. Full stop. Next para. in the light of such discussions, comma, in the present case, comma, the petitioner is also entitled to have a second lease of life by approaching the appellate authority, comma, since the writ petition had been filed only about 4 months after the final order of assessment. Full stop. Next para. Accordingly, WPA 10097 of 2023 is disposed of by granting liberty to the petitioner to prefer an appeal against the final order of assessment, comma, which has been passed by the WBACTCL in the meantime, comma, within a fortnight from date. Full stop. If such appeal is filed within a fortnight, comma, accompanied by an appropriate application or grounds in the appeal itself, comma, indicating sufficient reasons for the delay in preferring the writ petition beyond the period of 30 days from the final order of assessment, comma, it will be open to the appellate authority to condone the delay in preferring the appeal and entertain the appeal, comma, thereafter deciding the same in accordance with law upon hearing all concerned. Full stop. However, comma, it is made clear that such liberty is being given to the petitioner with the rider and being subject to the condition that the petitioner, comma, while filing the appeal, comma, shall also deposit the mandatory amount of 50% of the claim as envisaged under section 127 within bracket 2 of the 2003 Act to enable the appellate court to entertain such appeal, comma, in the event the delay is condoned. Not as to cause urgent certificate copies. Act line add করে দাও, parties as well as all concerned shall act on the server copy of this order without insisting upon a prior production of a certificate copy.
This order
Ah,
is
sir,
passed
sir.
considering the averment of the writ petition. Otherwise, my lord,
No, I have not directed the appellate authority to allow the condonation.
discretion of the appellate authority, let's say, said that.
He will consider. He has the power under law. He will consider. He will have to apply. It still remains on the discretion of the authority, and he has to put in that for 50%.
My lord, great.
Next matter will be taking up after 10 minutes.
Great.
intend to show the judgment of Dr. Chakraborty, my lord. Just if you
That
like-
you cited one.
That is Justice Mukherjee.
No, Dr. Chakraborty's judgment you cited.
That is polemic. I said that.
No,
that-
after the judgment.
No, I'm not on that.
No.
For your lordship, not for that, not for judgment. That the my lord, ultimately, my lord, the appellate authority says that within after 30 days I cannot renew the condone the delay. Writ court came, that judgment. my lord. That
Allowed.
Writ court my lord, ultimate dismiss.
Obviously. If the appeal court says no, then how can? Call on that.
Item 6,
I'm for the petitioner led by Mr. Partho Ghosh.
Mr. Partho?
Ghosh.
Yes. What is the matter?
My
What
lord,
about service on the?
I have already sent it via through post to the WBSADCL, but it came back 2 days back with endorsement refusal.
Refused is good service. Are you ready with your service, affidavit of service?
No, my lord, it's not completed.
From that affidavit of service, come back tomorrow.
My lord, I have served them yesterday also again via post. So I am expecting a.
No, if it's refusal, that is good service.
That is a
And when should I keep it? Tell me, whenever you like.
After a week,
Very good. On the prayer of the petitioner, the matter is adjourned till May 10, 2023.
if my lord can think fit for appointing an advocate on behalf of on behalf of WBSADCL, that could also be done.
WBSCDCL has refused.
Yes. That is the thing.
Are you sure?
Yes,
There is
my
no
lord.
private respondent?
I have the refusal slip. I have.
There is no private respondent involved.
No. WBSADCL and Ombudsman of Electricity Ombudsman.
Anyway, since I passed an order, let it be on 10th. Let us see whether something happens.
Okay.
Is the officer there, Dr. Shahara? Yes, he is there. Tell him this matter. Take note of this matter.
item 7,
7.
Item 7, my lord, I am appearing for the petition.
You're for the petition.
My lord.
You're for the.
But this is the affidavit of service.
Mhm.
My lord, the petitioner had preferred one writ application.
What about private respondent service?
My lord, they have been served.
Good service.
I have annexed the endorsement.
Yes.
My lord, on the last occasion also, they choose not to appear.
Oh.
My lord, the petitioner had filed a writ application before this honorable court, my lord, complaining
Yes.
that CSC was not shifting the meters of the private respondent from my plot of land to private respondent's plot of land. Your lordship directed the learned district magistrate to hear the issue and my lord to pass a direction. My lord, hearing was conducted and my lord, in the course of hearing, my lord, CSC had filed a report before the district magistrate. My lord, your lordship kindly comes to that report.
Page?
My lord, the report, page 63.
Yes.
My lord, dated 19th of December. My lord, there, my lord, if your lordship kindly sees paragraph B, my lord, CSC had said that yes, technically suitable place is the place of the veranda of the private respondent. They have done their job. Upon inspection, my lord, it was held that meter to be shifted from the land of the petitioner to the veranda.
Yes.
My lord, considering that issue, DM passed an order.
Achha, achha.
My lord, kindly comes to the order passed by the learned district magistrate. My lord, page 61. My lord, 23rd of December 2022. My lord, there it was a specific observation, a direction. Your lordship kindly sees the private respondents are present. The inspection report is submitted by the district engineer, Southern District CSC was received by this office. The said inquiry report reveals that joint inspection was carried out in presence of Sunanda Basu, Dilip Kanti Roy, and Arup Kanti Roy, and Shoikot Roy. And the police officials, Patuli police station are present. Dilip Kanti Roy had shown a new meter board shed, which has already been constructed by him for shifting the service of connection along with meter there. But here also Ms. Sunanda Basu has some objection. The said meter shed is about 1 meter from the existing location. Apart from this, Mr. Dilip Kanti Roy has so far failed to provide any alternative place for shifting of the service. Now CSC has reported that an alternative location has been found at the balcony of the house of the Dilip Kanti Roy, and the same is technically feasible as well. Therefore, under the above circumstances and after having heard all the interested parties in the petition, the district engineer is directed to shift the meter from the existing place to the proposed alternative site. The order must be complied within 2 weeks, but they have till date not done that. And my lord, the meter is still lying within my premises. My lord, this is third round of litigation. My lord, initially I had filed a litigation.
Do that.
Lordship, the private respondent were communicated and in their annexation in the writ petition, page 74, we have already communicated to them. They had to give some the service charges and all. We are ready to comply, but they need to comply with that. So once they comply with the formalities, we are ready to give.
Now, my lord, the private respondent.
The private respondents pay?
Because for the meter shifting, we have.
Oh, it's their meter.
It's their meter. Yes.
Now, the private respondent for the next 2 years will not pay because initially, my lord, they are not in a mood to shift the meter. There is severe objection before the district magistrate as well as.
Did the private respondent apply at all for shifting?
Lordship, as per the court's order, we were waiting for them to comply with that order.
So I'll permit them to put in the amount you do.
Lordship.
You pay the amount. The predicament. Yes. The predicament in the present case is rather peculiar, full stop. The petitioner sought for the electricity meter of the private respondent to be shifted to the private respondent's portion of the property. Full stop. Next para. Ultimately, with a order dated December 23, 2022, the district magistrate, South 24 Parganas, directed the CSC Limited to shift the meter from its existing place to the proposed alternative site at the balcony of the house of the private respondent. Full stop. Next para. However, such shifting has not yet been done according to the petitioner. Full stop. Next para. Learned counsel for the CSC Limited submits that in accordance with the extant regulations and rules, the private respondent, in whose name the meter in question is standing, is required to pay the shifting charges, which has not yet been paid by the private respondent, for which the shifting cannot be done. Full stop. Next para. It is clear in the light of the facts of the present case that the private respondent is not interested to such shifting. Full stop. Such shifting is being done under the purview of the order of the district magistrate, South 24 Parganas, vide order dated December 23, 2022. And, as such, in the event the CSC Limited awaits payment of the shifting charges by the private respondent, the order of the district magistrate shall never be implemented. Full stop. In such view of the matter, since the petitioner is agreeable to deposit the necessary shifting charges, there cannot be any hindrance in implementing the order of the district magistrate. Full stop. Next para. Accordingly, WPA 10294 of 2023 is disposed of by directing the present petitioner to deposit the necessary shifting charges within a week.
Within 2 weeks, man.
Within a fortnight from date. Full stop. Upon such payment being made, the CSC Limited shall implement the order of the district magistrate dated December 23, 2022 by shifting the meter of the private respondent to the proposed alternative site within a fortnight thereafter. Full stop. No orders to cause urgency.
Grateful.
আরেকটা লাইন অ্যাড করে দিতে হবে নো অর্ডার টু কস্টের আগে in the event any resistance is offered by the private respondent in the CSC Limited doing so, in consonance with the order of the district magistrate, it will be open to the CSC Limited to approach the officer in charge of the Patuli police station within bracket respondent number 5 bracket closed for such assistance, which will be given by the respondent number 5 by acting on a server copy of this order as well as a copy of the magistrate's order, at the cost of the petitioner. Thank you.
Grateful.
Grateful.
Thank you.
Item 8.
Yes.
I'm for the petitioner, my lord. I have served
all,
Yes,
yes.
my lord.
My lord, item number 8, my lord, I appear on behalf of the CSC. My instruction is, my lord, the copy has not yet reached us. So let a copy be given to us.
You are for the private respondent.
Private respondent, my lord, just received today morning.
Come back tomorrow. I'll hear it.
And my lord, there is some difficulty, my lord, in the same premises. My lord was one of the advocate on behalf of the mother of the petitioner, my lord.
It is fairly pointed out by learned counsel for the petitioner, for the private respondent, that I had appeared. What is this? You're saying that is sufficient. That I had appeared in the capacity of an advocate prior to elevation for one of the parties, hence, for the sake of judicial propriety, let the matter stand released from my list with liberty to the parties to pray for assignment before an appropriate bench. The affidavit of service filed today be kept on.
No, the copy may be.
I'll not direct anything. Please give a copy to him so that.
Item 9.
Yes.
Number 9 also, my lord, I
I'm for the petition.
the copy has not.
Service upon the private respondents are also.
Give a copy, come back tomorrow.
My lord,
Lordship,
request-
service
no,
upon
not
the
copy.
private respondents are also not.
Should I
complete.
take it up?
Lordship, after 1 week, Lordship.
On the prayer of the petitioner, since service has not yet been completed satisfactorily on the respondents, the matter is adjourned till May 10, 2020. 10th.
I'm great.
Mr. Haldar, if you can, please give a copy. To
Lordship,
Old matter, item 10 and 11.
In this matter, I've been led by Mr. Shubhishchandra.
Yes. The WBERC, Mr. Dhar was appearing. Is the WBERC a necessary party? Because Mr. Dhar's mother has expired recently, 2 days back. It was mentioned before me in other matters.
For other purpose, his presence may be required, but for the purpose of present issue may not be required, but if he might,
Why was the respondent of 5 implemented, WBRC?
the regulations, some statement has been made with regard to the application of regulations. That
Are you
is-
challenging the regulation?
No, no.
Then Mr. Chanel, if you say I can take up the matter, then
Up to your mom. Proceed.
move the matter.
মানে-
So only
Can I
one more
record your? Then I'll have to record your submission. You're not challenging the regulations.
No, 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 I am not challenging it.
পার্টি করেছিলে কেন?
কোনো করতে হবে।
Or I'll keep it afterward.
After,
Yes.
otherwise, for professional reasons.
Professional reasons, and suppose later on they come up and say some
As well.
factor is involved. I mean, I don't know. I have not heard the matter. So give me a date when I should keep it.
After his
Vacation.
After the
Summer vacation.
after summer vacation. He was not meaning that.
No, no, after his
After bereavement, he was
bereavement is over.
That takes us after vacation.
almost after the. No, I'll keep it on 17th May.
Do that.
No,
Mr. Shana, it will be very suitable for you also. That period of time. Very well. None appears for the WBERC when the matter is called on for hearing. Full stop. The learned advocate on record for the petitioner is requested to serve another notice on the learned advocate on record for the WBRC, indicating that the matter shall be listed on May 17, 2023.
Only one thing I'm drawing in my learned senior friends attention. My lord, probably my learned friend's client approached our client for sending it to Lok Adalat. Let my learned friend takes instructions on that.
No, no, no.
So
On the other hand, their officers repeatedly making phone call.
Good.
no,
Settle the.
it's not that. They probably anyhow.
Very well, Mr. Bhattacharya, you take instruction in the meantime, then please ensure that a copy is served and a notice is served.
Yes. Grateful.
না বলতে ঠিক আছে তুই জানিয়ে দাও যে বলতে বলছে আমরা করছি I think জানিয়ে দাও
Item 12.
Yes. You are for the respondent.
No, he's leading me.
Oh,
I tell
So
you,
CSC is a
lordship,
petitioner, sir.
pursuant to your lordship's last direction, we served notice, but even then they do not appear. I think because the matter has been settled. I tell you, lordships, there was my lord, total assessed amount 3,71,000. My lord, upon payment of
2,78,000, 75% as per the order of this honorable court, supply was restored. Now, my lord, consumer paid the balance amount of 92,891 on 7th September 2022. And thereafter, my lord, he paid for, my lord, total enhancement of load for industrial supply. And he further deposited the amount, gave the, my lord, load extra. I think he probably for that.
Is that a written instruction, Mr.
Written
Sharma? Can I keep it on record?
Yes, yes.
If I can keep it on record, I'll keep it on record and say it has been.
That's the reason he's not.
Yes, yes, obviously, it is obvious.
Excuse me.
Well, point number 8 and 9, your losses kindly consider.
Right.
6, 8, 9.
The dispute in the writ petition was regarding
We challenged the order of the appellate authority. We lost before the appellate authority. Page 51.
learned counsel for the petitioner submits in his usual fairness, comma, that in the meantime, comma, the private respondent has deposited the due amount of balance electricity charges, comma, upon which the electricity connection of the private respondent was restored.
No, restored was long back upon payment of 75,000.
0.3.
আচ্ছা তাহলে এটা কেটে দিন it is submitted by learned counsel for the petitioner in his usual fairness that the restoration of the electricity connection of the petitioner had been effected long back upon payment of an amount of rupees 75,000.
75,000.
75%.
75%.
আচ্ছা upon payment of an amount of 75 na upon payment of 75% of the final order of assessment plus meter replacement charge and reconnection charges. Puts up thereafter, comma, on the request of the private respondent, comma, the load factor in the said connection was also enhanced and due payments were also made by the private respondent on such score. Full stop as such, comma, apparently the cause of action raised in the present writ petition has become infructuous. Full stop. Keeping on record the written instructions filed by learned counsel for the petitioner stroke CAC Limited, comma, WPA 4893 of 2011 is dismissed as is disposed of as infructuous without any orders to cost.
One sentence. It is Lordship will find column number 8.
Pardon?
This need to be recorded. That he paid 75, then column number 8, point number 8, serial number 8. Balance.
যেখানে 75% বলেছি না 75% of the final order of assessment and subsequently the balance sum of rupees 92,891 on September 7, 2022.
Of the assessed amount.
Yes, I have added that to the sentence where I said the 75% of the assessment was after that balance amount.
Thank you. Disposed of. As a Lordship, please.
Item 13.
Well, let the affidavit in reply prepared by us be kept on.
No opposition has been filed. How can?
No, the opposition has.
Served upon us.
Served, not filed.
Oh, nothing else.
Leave it. কোন অ্যামেন্ডমেন্টের সঙ্গে আছে অ্যাপ্লিকেশন? The parties are unrepresented when the matter is called on for hearing. Full stop. It is seen from the previous orders passed in the matter that the petitioner has been seeking adjournment on several occasions. Full stop. As a last chance to the petitioners to move the matter, the same is adjourned for the day. কাল থাকবে।
Yes, my lord. I'm appearing for the petitioner.
Yes.
My lord,
State আছে।
my lord, I'm taking leave of your lordship to file my affidavit in reply along with the amended affidavit in reply because some information subsequent to the service of affidavit in reply to the respondent number 4 we
You have
got.
served copies on this?
We have already served, my lord.
Very good. Yes. What is the matter?
My lord, first, without wasting the time of your lordship, just inviting the your lordship's kind attention with regard to my amended affidavit in reply, page 2.
Yes.
I'm just starting from the third line. The one relevant document pertaining to the instant writ petition, that is the joint inspection report dated 22nd August 2022. What happened, my lord? Just here I'm just taking a pause. That on 22nd of August 2022, one joint inspection was done, about which I had made by averment in my main affidavit in reply, where the officials of Assistant Director of Fisheries, that is of the Assistant Director of Fisheries.
What is the gamut of the dispute? I mean,
Gamut of the dispute is one impugned notice that the land which we purchased, where we are making construction, it was actually, the notice was received on 10th of July. I'm just telling. On 2012, by memo number 740 of 2000 by 2, that this land is a pisciculture land. So it is a water body, so no construction can be done. But subsequent to that,
yes.
Subsequent to that, your lordships, we filed this writ petition challenging that impugned order. Thereafter, on 22nd of August 2022, one joint inspection was done by the respondent number 4 in the presence of the officials.
It was pursuant to the court's order or independent?
No. It is order passed by the respondent number 4 only, my lord.
Then what happened?
Thereafter, on 22nd of August 2022, when after the joint inspection was done, a report was published. My client was somehow managed to get a copy of that report. My lord, I'm inviting your lordship's kind attention with page 4 of my amended affidavit in reply. Kindly come to that. Page 4, Annexer AR2.
So existence of water body not found.
Absolutely, my lord. 6, para 6.
As you said, you managed the report.
No, my lord, it is actually joint inspection which was done in presence of, I'm just telling, my lord, this joint inspection
Yes,
was
you
done.
say, therefore, this notice becomes bad.
No, what my contention is that, my lord, whereas this is not at all a water body, which I made in my averment, this is a land where from the local people used to dig the soil, and because of that, the land was
water had accumulated.
And the earlier, actually, the time when they had seen that place, that was a monsoon time, June, July, and at that time water was there. But ultimately, after,
So you say the notice has to be bad.
Notice is bad in law, my lord, and my petition is actually this notice is to be quashed, and I may be permitted by your lordship in terms of my prayer to proceed with this land accordingly.
Yes, Mr. Oth, what is your
My lord, it appears from the order.
report? Joint inspection report is what is against you. In their amended affidavit in reply.
Yes.
Point number 6 there.
My lord, kindly see. I have seen, my lord. It has already been disclosed, my lord, in my affidavit also.
Achha.
In my affidavit also.
All right.
Rightly or wrongly, my lord, they are seeking for changing of the nature and character of the land.
Nature character means it was a football ground in yesteryears, your report says. 7, item number, the clause number 7, that the said land was used as football ground in yesteryears. That is according to local people, of course. At the said land, existence of water body or water were not found, and therefore the question of pisciculture does not arise.
And not only that,
they're wanting to construct, not pisciculture.
So, my lord, kindly have a look at, my lord, my affidavit in opposition.
After this joint inspection report, what remains, Mr. Datta?
My lord, the joint
And it
inspection report is says, but it appears from there, my lord.
Do you deny the existence of the joint inspection report?
No, certainly not, my lord. My officers are there.
Your officers are there. So how can you get over that? And why should we?
And my lord, it is done in front of their all senior officers, additional district magistrate, land
My lord,
reforms.
it appears from the report that the aforementioned status report and the revealed that the alleged pond has been formed into a depressed land, and due to the non-maintenance of the same by the owner, such and such, become the storage.
Recorded as Bastu land, Mr. Dottu.
Yes.
Point number 2 says recorded as Bastu land, was being used as a football ground. Probably a football was also lying there, I don't know.
Well, I think that, my lord, something fishy is there. In some document.
Fishy, because pisciculture has to be fishy. So how fishy they and your learned friend made a Freudian slip. He said that he managed to get a report of a joint inspection. So, but after this report, what can be done if your officers are so?
Only thing can be done, my lord. This can be set aside by directing the authority to take a decision about the matter after the proper inspection.
After this report, I cannot do that.
Inspection is already
Unless
done, my
you
lord.
challenge the veracity. I mean, you did not challenge the veracity. Of course, your officers should
It is
be.
their report, my lord. We have
If that this report is there, the entire notice is vitiated, Mr. Otto.
that is
And not only that, it's recorded as a Bastur, and obviously that was erroneously sent. I have to only set aside. And I cannot say in this case that subsequently I give you liberty to proceed in accordance. No, because if it's a Vastu land according to your joint inspection report, I cannot improve upon that. And why should I improve upon that?
No, if it is Vastu, my lord, in that event also there is a particular procedure. If you want to, my lord, to change the conversion of the land on the basis of the inspection report, that can be done.
My lord,
But the fact remains, my lord, fact remains, suppose, my lord, there is a entry in the record of rights that this is a Vastu, but it appears from that this is a depressed land.
Definitely.
my lord,
So, my
But
lord, the,
here that also is ruled out.
by going by the paper, my lord, whether the recording is incorrect or
What's
the inspection is incorrect.
my lord, in this regard, I am drawing attention of your lordship with regard to page 41 of the read.
And this is mostly based on local people's statements.
Person also from
So, my lord, the statement of the local people will not do only.
But
the
your officers did this, Mr. Otto.
and the person from whom I have purchased this land at that time also it was Vastu. How could we make conversion of that land?
What is the notice page?
Notice.
Notice. Yes.
Impugn notice is in their affidavit in opposition page number. It is annexer R41. It is page number.
Page.
I'm just telling you. It is 13, my lord, of affidavit in opposition filed by respondent number 4.
Notice is not annexed to the writ petition.
Notice is annexed to the- I'm just coming to that also. My lord. Sorry, I'm apologizing. my
My lord, page 13 of my affidavit in opposition.
No, I'll look into the writ petition. Page 13 of the affidavit in opposition. I have
My
to
lord,
look
it
for
is
the
page
impugn-
80, page 71, annexer P7, my lord. I'm apologizing, my lord, for the inconvenience caused. Page 71, my lord.
Oh, it was recorded as Bastu. That has been admitted, Mr. Dottor, in your notice also. Recorded as Bastu, but after an inquiry, it has been revealed. Another inquiry revealed it is not.
My lord, what they are seeking for a permission or the no objection from the aggregate. My lord, the
The construction has to be in accordance with law.
No. What they are seeking for a no objection from the below the Department of Fisheries. Department of Fisheries doesn't have any authority to do so. Because, my lord, by dint of the circular,
Oh, achha. Yes.
kindly have a look at, my lord, page 15 of my opposition. Only the commissioner, municipal commissioner and the executive officer of the municipal corporation is the competent authority. So now, my lord, the pisciculture will not do. They have to implement the commissioner as a party. They want to get the relief.
No, if the land is recorded as a Bastu, not an inland fishery, it does not come within the purview of inland fishery, rightly said by. So why should they give a no objection certificate in the first place?
Actually, the thing
You
is
told me that they have said that no, you have to convert it, but that conversion
Only given by the, my lord, the land
because of
response
and
department.
because of your application, you applied for a no objection certificate from the inland fisheries. Why? Please read out page 71.
Yes, my lord.
Read it out.
After an inquiry, it has been revealed that the said plot of land, Muja Samdahari, all details are there, area of 10 quarter 1880 square foot, found and actually a pond. This is the thing we are challenging, and though it was recorded Bastu as record in supplied, but it is my point of contention, my lord, is not at all a pond. This is a Bastu land. But regarding the construction, all those things, we will abide by the rules and regulations of the local municipality, my lord.
But this sort of inquiry, I mean, I have my doubts about this. You're during pendency of the, and that too without any direction of court. Of yourself, your officers go there. So
no, my officer, my lord, it is
I mean, his officers go with your client and they hold a joint inspection. No, I'll direct an inquiry. You are right, Mr. Dutta. It's not for you or me or him.
But
There
the
has to be a
depart,
further.
but the department would be land and land reforms department. Otherwise, the original records will not come.
In
Only
RTR
the
officers of
pisciculture
so land and
department
land
is-
department, the inquiry was done, my lord.
Why did you seek the no objection certificate at all?
My lord, actually,
They
they
are
are,
not the competent authority at all to give the certificate.
my lord, it is because of the declaration.
They intend to.
Why
get
did
a
you
con-
write to the assistant director of fisheries in the first place? It is recorded as a Vastu. Inspection shows it's Vastu, but that previous inquiry showed that it was a pond. So why did you apply in the first place, Mr. To the inland fisheries?
My lord, actually, after I am just, in that case, I'm drawing your lordship's kind.
And you are a company, Griha Nirman company.
Yes, Green Nirman company.
Why did you apply in the first place before the inland fisheries?
My lord, just I'm coming to this, getting this query, just a minute.
Mr. Dotto, you take charge. I'll direct another inspection to be held by your officers. Joint inspection again. This time, by the under the direction of the court, and a report will be filed along with connected documents if necessary. Because these are interdepartmental things. Connected
But
doc.
the officer of the land and land reforms department, because they are the custodian of all the records.
Acha.
The fisheries department nothing to do with it, my lord. My lord, if your lordship pleases, in that event, the land and land reform department can be implemented as a party respondent.
I
There is no
think so, yes.
difficulty. Any senior officer can go and inspect.
My lord, in para 8 of my
what?
writ petition, page number 13, my lord. I'm just reading it on, my lord. The petitioners made a representation on 17 September 2013 before the secretary, fisheries department on 25th October 2000.
Why? It was a Vastu land you were constructing. Why did you make that?
Actually, I'm requesting to grant permission filling up the land for the purpose of filling up that plot of land. We
After that filling up, we have then
thereafter
after the filling up, there was another joint inspection, and there it was
no,
revealed
filling
the
up was
land.
not done yet, my
A
lord.
football ground.
My lord, thereafter what happened? I'm telling.
Oh,
Thereafter this report.
He's right, absolutely right. Very fishy.
In that case, my lord, let them.
You sought permission for filling up the land. After that, it was seen that the land has been filled up.
No, land was not filled up, my lord. Thereafter, they had given that impugned letter, memo. That is the 10th of
What
July.
is the exact department, Mr. Dotto? These Vastu lands?
Land and land reforms department.
Impute them. Impute them.
Land and land use department.
A peculiar problem has arisen in the present case in view of a subsequent within double inverted joint inspection held by the officials of the Inland Fisheries Department and of the Fisheries Department of the Fisheries Department
My lord,
of the Government of West Bengal and the petitioner. First of it was found from the said inspection, as evident from a report to that effect annexed to the amended affidavit in reply of the petitioner, that the report gave a clean chit to the land in question, where the petitioner seeks to make a construction, with regard to the same being a Vastu property, which was apparently used as a football ground. Used as a football ground to double inverted previously, according to local people. Full stop. In point number 6 of the joint inspection report, it is also stated that at the said land, existence of water body or water were not found, and therefore the question of pisciculture does not arise. Full stop, next para. However, as fairly pointed out by learned counsel for the petitioner, the petitioner has averred in the writ petition itself that it had applied to the Fisheries Department for necessary no objection, since the petitioner wanted to fill up the land on the contention that the same was erroneously being construed to be under the Fisheries Department. First up, the petitioner's stand is that the land was actually a lowland, which had been dug up comma, due to which during the rainy season, comma, water had accumulated in the said land. Full stop. However, comma, the land was originally recorded as a
Kindly take two documents together, my lord.
fictitious. Originally recorded as a Bastu land. Full stop.
Both the report, my lord, serial number 7 is not there. The same report in my, my lord, affidavit, my lord, serial number 7 is not there. Kindly see, my lord, to the reports. My lord, it is my fault that I have not examined in previously, my lord. I think that, my lord, these two are not telling.
This is annex to your document.
Affidavit in opposition supplied by the department.
I'll record that. I'll have to record that. These are part of your affidavit in opposition.
Yes.
Very well. Full stop. However, comma, it is seen that the petitioner himself itself had applied to the Fisheries Department of the Government of West Bengal, indicating that the petitioner wanted to fill up the said piece of property, comma, which prima facie shows that even according to the petitioner, comma, there was necessity to fill up the land, comma, where water was found. Full stop. Next para. Moreover, comma, it is rightly contended by learned counsel for the respondent authorities,
My lord,
that the report annexed to the amended affidavit in reply.
my lord,
Just a minute. This is not the part of the evidence.
this is not a part of a business opposition because we have also copied. It is not there.
This is not the part of the report in the, my lord, the instruction that we have received.
As amended, then I have to keep it on record.
Yes, my lord, certainly.
Amended such and such, does not tally with another copy of the same report, comma, which has been handed over by the respondent authorities to their learned counsel. First up, a copy of the said joint inspection report, comma, which is filed today in court by the respondent authorities, comma, be kept on record. Full stop. It is clearly seen from the same that the same does not tally on all counts with that annexed to the amended affidavit in reply, comma, although both the reports mention that existence of water body or trace of water was not found on the land. Full stop. A suspicion arises, comma, since the petitioner itself had admitted that there was water on the land, comma, for which the same was required to be filled up, comma, for the specific purpose of which the application was made by the petitioner before the Fisheries Department, comma, which militates against the last report, comma, which indicates that there was no trace of water, comma, giving rise to the suspicion as to whether the same has been filled up in the meantime by the petitioner or any other party. Full stop. Next para. Be that as it may, comma, since the respondent authorities rightly point out that the land and Land Reforms Department. Since the Land and Land Reforms Department of the Government of West Bengal is the appropriate authority dealing with such Bastu lands, and keeping in mind that the land has been admittedly recorded as Bastu, comma, the petitioner is directed to implead the Land Revenue Department of the Government of West Bengal as a respondent to the present writ petition. Full stop. The necessary consequential amendment to the cause title of the writ petition shall be carried out by tomorrow. Full stop. A copy of the writ petition shall be served on the added respondent at the earliest, and an affidavit of service in that regard shall be filed in court on the next returnable date. Full stop. The matter shall next be listed on June 6, 2023 for hearing.
One small submission before you. Madam, respondent number 6 is block Land and Land Reforms Officer is there.
Department of the Government has to be implemented. They have the records. PLLR may not have the records. May not have the records. Mr. Dotto, if you can please take instruction on this because you will be representing the other department also. Obviously, yes. You also take instruction.
My lord, I'll talk. Grateful to you.
Item 15.
My lord.
You are for the state, yes.
Yes, my lord, I am praying for my lord, not today and not tomorrow only, because my lord, last 2 days I was absent. And yesterday the reply has been served upon the junior.
I'll take it up on Monday then.
Yes, my lord, let it be Tuesday,
Wednesday.
as you lord.
If not Monday, then on Tuesday.
Tuesday is a holiday.
That's why. On the prayer of learned counsel for the state, the matter is adjourned and shall next be listed under the same heading on May 10, 2023. Wednesday.
I'm grateful to you.
Affidavit reply filed today be kept on record.
I'm
And the
grateful.
affidavit, supplementary affidavit.
Why supplementary? No leave was there.
Supplementary, order dated 15th of December. Your lordship. granted
Affidavit
leave.
reply and supplementary affidavit filed today be
Yes,
kept on.
my
We
lord,
have already
I
served.
filed my lord,
We have
they
already
kept in
served.
opposition. I'm grateful.
Your lordship was already been give leave to file supplementary affidavit.
Application item 16.
My lord, I am for the petitioner. My lord, the read petition which was dismissed for default and the restoration has been filed. And my lord,
This is that restoration?
yes, my lord.
When was it dismissed?
My lord, it was dismissed for twice. My lord, the council was in Alipur court and till the time he came, the matter got dismissed for default.
You are the
And-
advocate on record?
No, my lord. And my lord, affidavit of service has been completed. My lord, kindly fix a date for a hearing.
You will have to pay cost. This is the second time you'll have to pay cost. Financial executive of some Bharati Axa or whatever. Pay some cost to the respondents.
My lord.
Affidavit of service filed today be kept on record. Full stop. Although sufficient reasons for the absence of the petitioner on the relevant date have been made out in the application for restoration, comma, it is seen from the records that the last occasion was the second when the writ petition was dismissed for default due to non-appearance of the petitioner. Full stop. Hence, comma, the petitioner ought to be imposed costs due to his repeated negligence in the matter. Full stop. Hence, comma, can 4 of 2023 is you are led by somebody in this matter?
Yes.
Who?
Saurajit Dasgupta.
Can 4 of 2023 is allowed, comma, thereby recalling the order dated March 31, 2023, passed in WPA 21542 of 2016 and restoring the said writ petition to its original file and number, subject to payment of costs of rupees 5,000 to each of the respondents by the petitioner, comma, which shall be paid within a fortnight from date. Full stop. The writ petition shall be listed for hearing in the monthly list of June 2020. The particular.
Part had matter. Item 17.
Tender apology, my lord. Yesterday I was.
Yes. You are leading Mr. Ananda Sundar Das. Yes.
কপি দাও সবাইকে ওনাকে
কি এটা?
On the previous occasion, when the matter was taken up, kindly takes this chart.
Hmm.
Milord, the comparison chart,
Hmm.
Milord, I wanted to, Milord, instead of showing it from the pleadings or from the documents appended to the pleadings, Milord, I wanted to, Milord, prima facie demonstrate that where is the grievance of the concerned, Milord, persons who are before your lordship's court. Milord, the concerned persons are all contractors. They say that the circular dated 26th March 2008, the extreme left-hand column, it in column 4 said accidents and payment. Milord, please turn to the next page, of compensation to contract laborers as per the Workmen's Compensation Act. Contract laborers, if sustained injury in course of and out of engagement, work of the company resulting in death or loss of limb, earning capacity shall be entitled to compensation as per the Workmen's Compensation Act, and such compensation shall be paid by the respective DDOs of the division through Commissioner Workmen. Milord, kindly pardons me for the spelling of division. Now, this was the prevailing situation in 2008. Then 2010 came, which was very much, Milord, on similar lines. Milord, it also says,
you could have given the page numbers of these circulars. That would have helped.
Milord,
Later on, ask you.
I will. এই page number গুলো কোথায় কোথায় আছে? Affidavit.
Just the page numbers that will help the court. Yes.
Milord, I'll just give you a lordship one.
Later on we'll.
Now, this 2010 is not annexed to the writ petition.
All right.
Milord, now,
anyway,
the next circular is 17/5/2013. That your lordship will be pleased to find. Your lordship may mark, page 27 of the affidavit in opposition.
So 2010 you did not place?
2010 is a part of the writ petition, but it's an illegible copy. I can make over a legible copy. It's not. It's 38 of the writ petition.
Legible copy.
A legible copy, I'm told, has been handed over to your lordship.
Oh, achha. Yes. Very good.
Now, then, 28 July 2022 is the immediate challenge, 28 July 2022 is the document, which is under challenge in the writ petition. In the writ petition. Now, that is page 56 of my lord's brief. Page 56. Now, I have.
Mr. Bhattacharya, I'm releasing the other matters before recess.
Yes, because after recess, I will also not be able to conclude, because there is a reason, I'll tell you.
Very good. Other matters are released before recess.
This B.Ed college, matters are going on before another court. People want to sit for examinations, which is Mr. Shomo Mujumdar is opposing. 10th is the examination. There are at least approximately 10,000 candidates who are intending to appear.
That always gets precedence, definitely. Yes.
And the matters are fixed at 2 p.m. before Justice Chondo. His lordship has been kind enough to pass n number of orders. Now he says that he will not, because the examination is on 10th. Now, here, this is thereafter the 28th July, I told you, lordship, page 56. Then, the next document, please come to this note that I have handed over to my lord, page 4. This is 12th May 17. 12th May 17 is also, page 44.
Thank you.
Now, a better copy.
Page 67 in my opposition.
Page 67 of the opposition. Now, while going into a little details of the matter, what transpired is, I wanted to ascertain from these persons, as to how and under what mechanism they are engaged. Because, it contemplates a labor license from the government of West Bengal Department of Labor. Labor license টা দাও, পেজটা বার করো। আর পেজটা বার করো, আমাকে পেজটা দেখাও, I'll just read it for the court. There, an interesting thing is there. That is, it contemplates, my lord, payment of compensation. এখানে আছে। My lord, it says, my lord, it says that one of the conditions of licensees shall maintain a register of supervisors and workmen in the form below and shall produce the register for inspection on demand by the electrical inspector or other person authorized in this behalf. Now, my lord, what I am on is, there is an issue here regarding supervisor. The law, or my lord, my engagement terms and everything it contemplated, my lord, that the supervisors will be deployed by my learned friend's client, who is going to supervise the entire scheme of things. And that is how it proceeded up to 2013. All on a sudden, my lord, there starts a deviation. My lord, what happens is, I am told that this entire electricity that is, my lord, that the end user, the consumers that are getting, my lord, that is totally, my lord, under the control of the SADCL, my lord, and the SADCL does it through its own, my lord, staff, some, and through these contract laborers. So their own staff, my lord, I am told that now, because of the system of governance, my lord, own staff is minimized. Why? Because own staff would entail, my lord, lot of ancillary benefits. My lord, pension has to be paid, gratuity has to be paid. So if it is, my lord, hired through an agency, then it becomes the agency staff, and it becomes a contract labor.
Contract labor, yes.
And so therefore those paraphernalia, my lord, will prevail. Now, my lord, what happens is, my case is that if the own staff, if SADCL's direct staff, and my lord, assuming both of us, one of us are SADCL staff, my learned friend is a contract labor, either of us meet with an accident, my lord, the law contemplated previously that the principal employer SADCL would, my lord, pay the compensation to both.
Workmen's compensation.
Workmen's compensation. Now, my lord, it is a deviation. Insofar as I am concerned, who is a direct employee, compensation is to be paid by SADCL, because that is by terms. Insofar as the contract, my lord, an inspection, investigation, and, my lord, blacklisting, or, my lord, stopping the work, all these things which were not there initially. And first and last, and but not the least, my lord, the compensation aspect has been, my lord, devolved on me, or on the contractor.
Yes.
Contractor has to entail and, my lord, the act may be, my lord, it contemplates, my lord, recovery under original section 5 or section 12, whatever. Now it is 85. Now, my lord, prima facie, what I want to demonstrate to your lordship, that all these decisions run contrary to the very essence and scheme of the act and my engagement. My lord, I cannot, my lord, today I have checked it. My lord, certain clauses of my work order, my lord, prima facie would be against me also. Because I have, my lord, those are all what is known as, your lordship knows, my lord, better than any one of us, dotted line contract. Because those are, my lord, one-sided. Whatever the term they are offering, I have to accept it. So one of the terms is in line, is in sync with this present scheme of things. Previously, that was not the prevalent system. Now, my lord, today, because of this,
one of the contracts among these people.
Yes. But today, what happens is, this entire scheme is outsourced all over the state of West Bengal. It is not necessarily restricted to a particular district. The work orders, my lord, what happens is, I have ascertained, my lord, in their website,
my lord, invitations are made for renewal of license or, my lord, for appointment, engagement as this particular contract. Now, my lord, this previously had certain terms. Now they have been revised to include certain more terms, and, my lord, certain terms have also been excluded. Ultimately, what happens is, on response, they are licensed by the SADCL authorities. This license issued by the SADCL authorities enables them to be favored with work orders issued by the, my lord, the substations.
Yes.
The substations. They engage them on by virtue of that electrical license. My lord, electrical license is one part issued by the SADCL, and the labor license is another part which is issued by the government of West Bengal. Now, I have instructed Mr. Ghosh, my lord, to prepare a, my lord, because these documents, my lord, I have been able to lay my hands on in course of, my lord, discussions, and it appears that, my lord, the SADCL in their affidavit only dealt with whatever my case is, instead of, my lord, dealing with certain documents which, my lord, inter alia include a decision, an office order number 4 dated 8 June 2021, which is not a part of their affidavit. This is, my lord, this was issued by the Director HR on 8 June 2021 towards minimization of accidents due to unsafe conditions in SADCL's system. And unsafe act of technical workforce and action plan has been formulated. Now, this formulation needs to be shown to your lordship's court.
That does not have statutory effect.
None of these.
Then you have to annex that to a something. At this hearing stage,
because, my lord, for the ends of justice, my lord, I want to come back. My affidavit is ready. My lord, I can give him an advance copy. My learned friend so wants.
If you feel it's really
no, it really is. It really is. My lord, according to me, it really is. For the end, I will, my lord, I will only, my lord, requesting your lordship, if it can be taken up tomorrow, let him go through the affidavit. I don't mind tomorrow.
Tomorrow will you be able to take instruction on that?
Because these are all their documents, not my documents. My lord, 8 June 2021 is one. Then 3rd December 2021 is deduction of supervision charges from 15% to 10% of the total estimated cost of materials and labor as per cost schedule for development of electrical infrastructure towards effecting new service condition under.
Why is this relevant, Mr. Bhattacharya?
These are relevant because this supervision charges, supervision, this word super, because all things today boil down, who is liable. We wouldn't have come to your lordship's court rushing had 2008 and 2010 system prevailed.
So supervision charges are shown there.
Yes.
To be paid to their officials.
Yes.
I'll permit them to use a supplementary affidavit, Mr. Paja. They'll give copies to you. When do you want to come back? Tomorrow?
Tomorrow?
Tomorrow, yes.
Monday, I'm telling your lordship, I am in difficulty, not for any other reason. It's a professional commitment.
Then Wednesday?
Wednesday.
You get almost 1 week's time. You get 2 holidays in the meantime. You will file on the next date of
yes.
So that he can go through that and take instruction in the weekend.
Yes.
Very good.
Would it be possible? My junior is requesting on 11th. Do you have
Yes,
any
why not possible?
problem?
Yes, Mr. Bhattacharya, then 11th.
11. I don't know.
Very good. Within single inverted comparison chart is handed over by learned counsel for the petitioners. First of the petitioners also seek to rely upon certain subsequent certain documents, which have come to the knowledge of the petitioners subsequently, but might have germane bearing on the adjudication of the present writ petition. First up, next para, hence on the prayer of the petitioners are granted leave to file a supplementary affidavit annexing relevant documents and making the necessary averments in that regard. First up, such affidavit shall be filed on the next returnable date. First up, an advance copy thereof shall be served during the course of the day to the learned advocate for the respondents' authorities. First of the matter shall next be listed on May 11, 2023 for hearing.
Just for your lordship's assistance, just one more minute.
Yes, yes.
The work order, which is usually issued by from their end. It in clause 35, I'm indicating to my senior, if the contract labor meets with an accident while working on the system of the company resulting in death or loss of earning capacity of the labor, his legal heirs, concerned labor, in case of loss of earning capacity, shall be paid by the SEDCL through, this is the 2022 work order. By SEDCL through the Commissioner of Workmen's Compensation following guidelines, etc.
That is very relevant.
So this becomes, my lord,
So this will be annexed to the supplement.
yes, it is already annexed, my lord, it is already annexed. And I am also telling Mr. Das, there is a labor license issued by the government of West Bengal.
That format will be.
That format, but there is also one clause regarding compensation. Please.
But it will have to be done during the course of the.
Yes, it will be done. I am, my lord, telling, my lord, it will be done.
Very good. Thank you.
Supplementary time.
Yes, after recess, not this matter, other matters.
Grateful. সোমবার একটা ছুটি করাতে বল, সোমবার একটা ছুটি হোক।
Part heard matter, item 18.
My lord, Mr. Thor is appearing for the respond number 1, my lord, WPS. I am praying
When
for
should I keep it?
after action.
Yes, Mr. Court.
I obviously, sir. My lord, 1 week after action.
1 week after vacation?
My lord, the first week, my lord, I will not be here. My lord, for that.
Yes, very well. On the prayer of Learned Council for the WBERC, the matter is adjourned till June 12, 2023.
Yes.
For hearing, item 19 and 20.
But I am for,
20 I'm appearing for the
show করছে না কেন?
but I am for the petition both the matter.
ঠিক আছে? Sorry. Yes, you're for this
Petition.
I'm
license.
PSC DCL, my lord, item number 20, my lord.
This is for the new connection of it.
19, who is appearing for?
19, my lord, Mr.
Yes, both. Yes,
I am appearing for.
very. New connection.
New connection.
Why not given?
Landlord given objection. He has not been signed in my form, therefore they are.
Landlord has been appearing in the matter.
Yes, Lord. He is appearing in the matter, but he has filed eviction suit against me. Therefore, he do not want to give the electricity.
Has any order been passed in the eviction suit?
No, that is going on.
So both of you, this is regarding the same property? 19 and 20?
Two rooms.
Achha.
2 rooms.
Actually, it is a actually not properly room. Lordship, kindly see, I have given the photographs. Today I could not bring my brief. That's
Well,
the
I
problem.
have annexed the photograph. I have annexed the photograph, your lordship. That is
I
supplementary
have also
affidavit.
given the photograph where it shows that it is a tent type. No meter room is there, nothing.
Is it possible to install there?
Yes, Lord, that
Very
is the
difficult.
electricity from my neighbor I have taken. But they have given objection that he is, therefore,
Whether it is technically feasible to install a meter there?
yes. Yes.
I am appearing for the private.
Yes.
Have the land.
What is your objection?
On the last occasion, your lordship,
Suit has been filed.
reply has been filed. Opposition.
Please take the microphone.
Opposition and reply has been filed. And my learned senior friend asked to file a supplementary affidavit on the last occasion, which he has served to me. In the
Yes,
supplementary affidavit, there is nothing, my lord. Only the photograph of the meters. That meter is a sub-meter. And that connection has been illegally occupied by the tenant,
So they are now wanting to legally take a connection.
my lord.
So you cannot have any objection to that.
My lord, since the inception of the tenant, there was no such electric connection from the beginning. And eviction suit is pending before the trial court, my lord.
Irrespective of that, they have a right to get electricity connection.
But kindly, my lord, come to the order of 22nd February, my lord.
Yes.
22nd February. Wherein the board has submitted one report, and it submits that the
Yes, that is being submitted.
uh,
No infrastructure.
no infrastructure, my lord.
Kindly.
But not so dilapidated that you cannot give a connection. The photograph has been given.
After complying necessary formalities and if he
Yes.
can provide the space for meter
Yes,
room or
Lord.
But
May I something, one thing, my lord? In my opposition.
Microphone.
Well, in my item number 20, my lord, my affidavit, I have stated, my lord, whether they are the petitioner's premises is condition is very bad. If I give their connection, my lord, there will be a electrical hazard, my lord. And one more thing, my lord, connection there is needed a concrete cemented pillar, my lord.
But the same premises,
I
the
have
premises are the same.
Yes, my lord.
So photograph has been annexed in the
Yes, my lord. That is the premises, my lord. No cemented pillar, my lord. No concrete wall is there, my lord.
just like
So
the
these
pay-
photographs show
No,
that
my lord. I have my lord, WPA 4304, my lord. I have
same case, same thing.
Same thing. but-
here also photograph has been given.
Yes, my lord.
it's a thatched hut proof, my lord.
Pardon?
Yes, a hut.
It's a hut. Thatched with.
But you are enjoying your electricity there also.
My lord, I'm
Yes.
the landlord, I have a building.
If landlord can enjoy in a hut, the tenant cannot.
I'm not residing in a hut, my lord. The tenants, there was subsequently 3 tenants.
You are
And
residing elsewhere,
elsewhere. No, in a same.
under the same roof.
Not same roof, it is a different. It's all thatched roof.
But there is no domestic condition is there.
What domestic condition? Domestic, it is not required to be domestic condition. I mean,
My lord,
they're wanting, they're somehow living there as tenants. They're tenants, that is not disputed because they filed an eviction suit. So their occupation cannot be disputed.
we have,
Have you held an inspection?
yes, my lord. Yes, my lord. In my inspection, my lord, electricity board has been.
But this property does not tally with the photographs annexed by the petitioner. Manwara Begum is your matter.
Fine.
Manwara Begum, if this is the premises, this photograph,
Yes, my lord.
but you have taken it from outside, but inside they have indicated that it's like this.
No, my
No,
lord.
this is different. This-
Photograph is also
My
there.
my instruction, my lord, that is the premises, my lord. And that is the situation of the premises, my lord.
Same
There
premises.
is
have
no
to have-
cement pillar, there is no cement.
If there is a pillar, they will give the pillar. I shall provide the money.
No, you'll have to provide the pillar then.
Yes,
They
brother.
cannot construct. a
Yes,
pillar.
brother, I shall.
Meter room, there is no such meter room also.
If there is no space, how can it be given?
Brother, I shall give the space.
If there is no space, how can you
No,
give
there
it?
is a space. Lord of the, let them go, shall I shall provide.
Sir, direct another inspection then in both the
Inspection,
matters.
my lord, inspection.
In your presence as well.
In my presence as well. And,
Both of you, yes.
Another point I'd like to submit before Lord.
Yes.
If such electric connection is given in that particular premises, it will be hindrance for me for further construction of my building, my lord, which is very much.
That is other thing. That,
That is the real cause.
yes, brother.
That will not, that is.
If they are tenants in respect of the premises, they are still enjoying, your eviction suit is pending. You cannot oust them there like this.
No such electricity was there from the inception of the.
That is other thing.
And
Brother, we
as
have
well as
taken
eviction-
electricity.
Now they are
from-
wanting electricity.
Eviction suit is also pending, my lord.
So what?
Social.
Learned
Long
counsel
period.
for the petitioner submits by placing reliance on the photographs annexed to the supplementary affidavit in both the matters, comma, which arise under similar circumstances and in respect of the same premises, comma, with regard to different tenancies in different rooms, comma, that there is ample space to provide electricity connection to the petitioners in the matters, comma, who are admittedly tenants. Full stop. Next para. Learned counsel appearing for the WBSEDCL in both the matters submit that an inspection has revealed that the location in question is not fit to give an electricity connection. Full stop. Moreover, comma, it is submitted that there is no space for a meter room and or construction of a pillar, comma, which will be necessary for such purpose. Full stop. Next para. Learned counsel for the petitioner, comma, however, comma, submits that the petitioners will be able to provide a position where the meter can be installed if given.
Yes.
Full stop. Next para. Learned counsel appearing for the private respondent,
Number 6.
number 6, submits that an eviction suit is going on between the parties against both the
Yes, yes,
parties.
two,
That-
two, yes.
that eviction suits are pending against both the petitioners. Full stop. Moreover, comma, from the inception, comma, the petitioners have not been enjoying any electricity connection,
My lord.
and comma, as such, comma, if such connection is given, comma, the landlord stroke respond number 6 might have difficulty in making his own construction. Full stop. Next para. As regards the objection raised by the landlord, comma, the same cannot be accepted, comma, since mere pendency of an eviction suit does not entitle the landlord to oust the petitioner by depriving the oust the tenant prior to adjudication of the said suits, comma, by depriving the tenants from getting basic amenities in respect of the premises. Full stop. The right of the petitioners is guaranteed under section 43 of the Electricity Act 2003, comma, to get independent electricity connections in the event the petitioners show their occupation. Full stop. In the present case, comma, there is no doubt as regards the petitioners being in occupation of their respective tenanted premises. Full stop. Next para. Since the petitioners have submitted that it will be that they will be able to provide space for installing a new meter, comma, the WBACDCL is required to hold another inspection, comma, in the presence of the petitioners as well as the private respondent, comma, to ascertain whether new metered connections can be given to the petitioners in both the matters, comma, even if no meter room is existing at the same premises, comma, either by direct connection or by providing improvised provision for giving such connection. Full stop. A report in that regard shall be filed on the next returnable date. Full stop. The commission shall be held with prior notice to the petitioners and the private respondents. Full stop. Such process shall be completed within 2 weeks from date. Full stop. The matters shall be listed together on May 17, 2023, when the WBACDCL shall file their respective reports in both the matters upon service of advance copy of the same on the learned advocates for the petitioners as well as the private respondent. Please see whether improvised any arrangement can be made to give connection. They have a right.
This is nowadays electricity is an essential commodity. So very tough to do.
17th of May.
17th of May. Report has been
17th of
21.
So we have nothing to say in this.
No, you can file reports.
Everybody wants to know.
Yes, Mr.
Three very important facts of this matter. Number one is I am a defaulter.
Tell me the matter has become infructuous.
No.
That
It's
is the most
live.
important.
And to remind your lordship, my lord, this is a matter where your lordship is totally against me.
That is very disarming.
The first thing.
Yes.
So
Maybe file the affidavits, man. Pleadings are
ready.
the three main reasons why your lordship is, my lord, against me is that A, there have been several occasions where I have been unable to make payment of electricity bills resulting in disconnection. Number two, despite an opportunity of reconnection, I have again failed to pay, resulting in further disconnection. And number three, in one of the appeals from these series of disconnections and writ petitions, in my desperation, I went and I filed consent terms before the division bench, agreeing to make payment in a certain way. I again failed to pay, which resulted in a further disconnection.
So thrice.
Yes.
Thrice.
I am sure if my history is examined, there may be more. However, the fact of the matter is that I thereafter have come before your lordship saying three things. Number one, a DP delayed payment surcharge, or what is called DPS, has been charged by DVC from me, which is illegal. Such a charge is without statutory force and cannot be done. On today, on this day, my lord, I am entitled to 24 crores plus interest from them. Because this is, my lord, money which has been taken from me under mistake of law, without any legal sanctity. And my cause of action, this is not
in lieu of the DPS.
Yes. And my cause of action arises as per various judgments, my lord, on the day when your lordship said that this is illegally collected. and without authority of law.
Cause of action for recovery of the money.
Cause of action for recovery. Unlike, my lord, a case of mistake of fact, where your lordship would look at my due diligence. You see, when did I come to know? Now, under those circumstances, when I realized that out of a 40 odd crore claim, which I had to make payment in installments, a sum of rupees 24 crores is part of DPS. I went to them and requested them, please reconcile. You don't have to pay me back. The security deposit of which is a bank guarantee of around 10 crores, 12 crores, you use from this. And let me start because my factory is non-functional. They have, my lord, refused, which is why I am before your lordship. In the affidavit, their stand is, number one, there is a consent decree which results in constructive res judicata. You have yourself gone and said, I am going to make payment. My answer, my lord, is consent decree cannot be res judicata because nothing is decided on merits. Consent decree or a decree on without adjudication does not result in res judicata. At best, my lord, an agreement may be standing in my way. But when that agreement, my lord, happened, my cause of action for recovery of the money was not there. Your lordship's judgment is later. So, my lord, the argument of consent decree cannot be varied, constructive res judicata doesn't, my lord, lie. That's a subsequent cause of action. Next, my lord, is they say that there were reconciliation meetings and I am giving you whatever. There's no difficulty. It's an admitted position from your demand notices that a large part of your claim was on this charge. And in any case, your lordship can direct a reconciliation before anything else. So, my lord, to sum up, before taking your lordship to maybe 3 or 4 documents, because my leader in the matter, Mr. Ratnanko Banerjee, had argued this on, not extensively, your lordship would remember. I don't want to dilute his submissions. But the fact of the matter is this. Yes, it is wrong on the part of an industry to fail to make payment of electricity bills resulting in disconnection. There are various factors. Nobody wants a disconnection. There are various factors. But at the same time, it is equally wrong on the part of the authority to collect money without sanctity of law and then to retain it. This is unjust enrichment as per the Supreme Court. And today, all that I am asking is you use it. Either you pay me back or you use it. You won't do that. That is wrong. Now, we'll have just a few documents. The first document, I'm not going into the history. Lord, please take it that there have been disconnections earlier. My factory was lying disconnected, qua electricity. I filed a writ petition, did not get an order. Matter went to the division bench. Before the division bench, we filed a terms of settlement. Please see that order once, below. Now, page 126. The writ petition was dismissed on 16 September 21 at page 123. In the appeal, a terms of settlement was filed at page 126. Lord, please turn over to page 129. Cause title ends. Lord, the terms of settlement is set out in the order. Lord, at page 130, it is agreed between the parties that the appellant shall pay a sum of 51 crores with delayed payment surcharge as applicable in 60 monthly installments. The first of such installment shall be paid within 2 working days. So this is with delayed payment surcharge. And then, my lord, page 131, paragraph 7, delayed payment surcharge will be applicable on installments against earlier dues in terms of the West Bengal Electricity Regulatory Commission regulation.
So you agreed to delayed payment surcharge?
Yes, Milord. Yes, I agreed. Milord, but please, that's why, Milord, I was saying when I opened that, yes, I agreed. It's a contract. I agreed. But this is dated 30th September 2021. And Milord, your Lordship's judgment is later. Now, after that, Milord, this is in 2021.
But you failed to pay the first installment also.
We, some 12 installments, I think we paid. Thereafter, in July 22, we failed to make payment. By this time, we had paid 20.
Mr. Chaudhary, when you failed for the first time to pay the installments, at that point of time also, that order had not come in. So your cause of action on that was, it was concluded. I mean, you failed for the first time before the order setting aside that DPS thing.
Yes.
So
Milord,
your rights were concluded then. I mean, you could not revive a past cause of action by virtue of a subsequent order of court. Even if subsequently it is said that that is illegal. Suppose illegal was not the term, but yes, illegal suppose.
Milord, it's a
You already lost your opportunity. You had you agreed to pay DPS. You did not pay the 12 installments. After that, you did not pay. So that chapter was over before that judgment came. How can you take advantage of that?
So that's why, Milord, my learned friend is saying it's res judicata. Over, Milord, has to be res judicata. It's an interesting question of law.
Res judicata exactly, but Mr. Chaudhary, this is a penumbra region between res judicata and your right being alive. Your right to claim benefit of that, I mean, that was over. A right that was not even an inchoate right at that point of time. You did not have the right to get the adjustment.
Now, Milord, may I make an argument?
Hmm.
Two things. I can be barred because it's res judicata. There is also a principle that my cause of action merges in a judgment of court. That's a very established
Merges in a judgment of court, but not post facto after the cause of action.
No, Milord. See, I have whatever cause of action I have, that merges in a judgment of court and it's res judicata. So when this judgment comes, it's res judicata. There is no other principle of law which prevents me, Milord, from agitating the same cause of action again. There's no other principle of law apart from res judicata. Now, kindly consider it. Apart from res judicata,
Order 9
nothing
principles
prevents
are
me.
also there. Order 9 principles are also there. Order 9 Rule 9 principles are there. But that is a different aspect.
That's a different,
not covered.
Essentially, the principle of law is that if
There are several circumstances under which you can be debarred. The cause of action spent itself, the res judicata, Order 23, Order 9, Rule 9.
But all
there are
of
other
it
aspects
is,
also.
All of it is if you go to a court and if the court decides, you can't this way or that way go to another court.
Now, Order 23 is your action. Order 9 is your action.
Yes.
Order 9 Rule 4, Order 9 Rule.
By agreement before
By
court.
agreeing or accusing or, I mean, you're stopped sort of.
On the original cause of action. Now, what comes out of it is this. I went before a division bench and I file a terms of settlement. Terms of settlement is an agreement between the parties. Your lordships have merely...
Has more sanctity, Mr. Chaudhary, before a court of...
No, it's only one extra, my lord. Agreement between parties. The fact that it is lawful has the stamp of court. Otherwise, it can't be accepted.
Right. Right.
So, this is an agreement.
Cannot be res judicata under any stretch.
Cannot be res judicata.
No.
Now, my lord, this agreement between the parties, which was accepted on 30th September 21, is subsequently rendered unlawful.
This was 30th?
September 21.
And when was that order passed?
24th January.
A fateful order, 24th January.
2022.
22.
So, there are two ways of looking at it. Either I start with a cause of action, go for an adjudication, which is not complete.
Was that writ petition pending at that point of time? Probably not, probably not.
Even if not pending, my lord. Because my learned friends, my lord, have found a judgment.
Then
of this-
nothing will attain finality, Mr. Chaudhary. Nothing will attain finality. You agreed before a court of law that got the endorsement of the court.
Yes.
Yes, legality, validity, whatever. That was recorded by the court.
Yes.
You failed to honor that. I mean, you failed to abide by that.
But that is rendered unlawful. But my failure, I am willing, my lord, to make good my failure. My lord, I am not an unethical litigant who says that now you give me, now I'm going to enjoy 24 crores you have obtained by way of DPS.
Not that, Mr. Chaudhary, but your failure, the first failure to pay the installments,
Yes.
that took place when this judgment of January 22 was not there. So at that point of time, even at that point of time,
No, it's
you had
after the judgment.
Oh, you have failed after the judgment.
After the judgment.
Then it will be
Failed after the
interesting.
judgment. Much after, but I'm not milled on that. It's now the question is.
But you went by the
I
agreement.
agreed to pay DPS.
Yes.
I agreed to pay DPS at a time when DPS was illegal. I'm sorry, at a time when it wasn't even decided whether DPS.
You paid
was-
12 installments. You
Yes.
abided by that agreement.
Yes.
And subsequently, when you failed to pay the one of the installments, by that time, but even after the judgment was passed, 24th January 22, you had gone on paying the installments.
Yes.
So you abided by that agreement throughout.
Yes.
This conduct cannot
Now,
be given a
Milord,
sanction.
now what am I saying now, Milord? Now what happens if I don't pay in terms of this judgment? What will happen is the repercussions will kick in and electricity will be disconnected. Now, when I go back for reconnection, it's a fresh cause of action.
Did you ever ask for that adjustment of that amount?
Yes,
in
I
terms-
did.
You asked-
Not before my failure.
No, not before your failure. After, your
After
failure,
my failure,
you relied on that judgment and you said
yes,
that
I said that, look,
adjust.
and I didn't even say that you pay me or let me enjoy 6 months of electricity.
Adjust it with my.
I am saying you keep my security deposit and you want a security deposit of 10 crores. So you're holding on to 24 crores and you can't. Supreme Court says that it's unjust enrichment. So if your lordship today, my lord, looks at it clinically, this division bench judgment cannot decide on my rights forever till kingdom come.
That judgment, my judgment is sub judice now before appellate court.
Yes.
So I'll hear it after that.
But I can't be without electricity after that. Till
Go
then,
before the
Milord.
appellate court and say that all my connected applications are being adjourned till. Because you're taking advantage of something which was not there when the agreement was entered into.
That is my right. Otherwise, I would not be able to. But this is the situation. But I have a right, Milord. Because I have a right ethically, because as of now.
Don't speak of ethics, your client.
No. A defaulter can be ethical.
Yes, not on the default.
No, Milord.
The cause of action of this is entirely revolving around default.
Milord, default can be for.
He may be a very good
business
person
reasons.
as a human being.
Default
very
can
good
be-
company.
I don't have money.
Defaulted thrice.
I don't have money. I couldn't pay my electricity bill. So that's why I'm coming and I'm paying for
even
the
after that, Mr.
consequences.
Chaudhary, you came up and asked for reconnection and entered into agreement before division
Yes,
bench.
yes.
And this conduct cannot be approved of by the court. I mean, you entered into an agreement. Subsequently, that agreement, you say the agreement does not go as a whole. The agreement does not become illegal in that sense. Because if you agree to pay a particular amount, you say whatever you have charged on account of DPS, I'll also pay. You agree to that. Subsequently, an order is passed saying that DPS cannot be charged. But the incidence of charge in your case is when you entered into the agreement, Mr. Chaudhary.
So, Milord, their demand for DPS and the inclusion in the agreement is illegal. It has been rendered
Post facto
illegal.
held to be
Yes.
illegal by a
The
court.
Contract Act, a contract which is illegal or which becomes illegal. This is a contract which has become
Contract-
illegal.
Why do you say the contract has become illegal?
Because of Milord, consent terms. It's a contract. Contract to this extent, Milord, has become illegal. There are legal problems. I am armed with a few judgments. It's possible to argue.
Possible to argue, definitely. It's a very good arguable point. But
the only difficulty which I am facing is because the earlier judgment was your lordship's judgment. Your lordship is, my lord,
allergic.
And it's, my lord, pending in appeal before division bench. Your lordship is hesitant, my lord, to give further effect to it. As of the present, which is
one of the
a
reasons
laudable,
it is
my lord,
my judgment is
approach.
one of the reasons, definitely.
Yes, it's a laudable approach, my lord. I completely appreciate it.
Then applaud and desist till the appeal is heard out.
Right, but my client, my lord, is not going to applaud on my performance.
Definitely not.
If, my lord, we have a shut factory.
And maybe in
That is the point.
inaudible terms, but also not the process adopted by the court.
Also, my lord. My lord, at the end of the day, my lord, there's nothing more on facts we can do.
Hmm. Yes, you show your judgments, whatever that.
My lord, I was asking, I said 10 crores is the problem. You make an offer, put in 5 crores, I'll, my lord, request
That
Mr.
can be considered.
Majumdar that come down 5 crores, you're anyway sitting on 24. If the judgment goes against me, go and disconnect. If I don't put in 5 crores, then. 5 কোটি দিতে পারবে না?
Then Mr. Chaudhary I'll keep the writ petition pending till the decision of the appellate court. And if they agree, then I'll direct restoration upon payment of cannot.
Nah. 5 installments, you get paid. 5 installments, after 1 month, you get connection. Weekly installments. No, I'll proceed. Right. Factory is closed for a long time. You won't be able to cough up 5 crores tomorrow. It's. Milord, let me, Milord.
Cite your whatever
I
judgment.
can't, Milord. No. Is it? Milord, may I take a?
Absolutely, please.
Milord,
If it can be solved, that will be the best
What
thing.
I was suggesting is the whole fight is about a 10 crore security deposit. 11 crores, which we wanted adjusted from the 24 crores. So if you put in half of that,
Or security deposit 50%.
subject to the division bench judgment.
I cannot.
No, subject to this writ petition, that's why I'll keep
Yes,
it pending.
This will be.
Because this
before-
will be subject to ultimately the division bench.
Correct.
The
And-
entire issue here is my judgment. It
And
comes in the
if the judgment goes, it will come before your lordship. Your lordship will give me a.
Go and disconnect.
For bank guarantee, I don't think for 10 crore bank guarantee, they have to shell out 10 crores subject. 10% margin.
Now it's 100%.
Now,
margin.
yes. Yes. In some other matter, it was pointed out. I don't have any idea of
I
10
don't
crore
have
bank guarantee at all, personally. But
What is your monthly consumption?
if the factory is closed, Mr. Chaudhary, you are not.
No, Milord,
You want to restart.
Again, Milord, essentially being a commercial lawyer trying to, Milord, work out a settlement. Their exposure
Right.
is as regards monthly consumption. So, Milord, I would have suggested, if I had known what the consumption was, first put in first give a bank guarantee for at least 2 months of consumption. Get reconnection. Then in the next month, put in the balance, Milord, to make it up to 5 crores. So that they are not prejudiced, because what happens is, if I give a lesser security deposit.
It will have to be commercially viable in their perspective,
Yes,
from their
Mr.
perspective.
Majumdar is there.
So
He'll
you
help.
can take instruction, come back, after 2 days. If it can be resolved, then no issues on that.
I mean, I cannot.
Definitely,
take
no,
this
you cannot.
I cannot take this.
Please don't.
No, I
You
will
cannot.
never venture even. But my lord, I will take instruction. My lord, let them suggest whatever they are.
I will go at 4:30 and suggest and come.
By that time, I will leave.
No, Mr. Chaudhary, the highest amount up
Then
to which you can go and the lowest amount to which you can stoop.
Milord, at the end of the day,
it's
he's
all-
my vice captain.
Where? There.
No, Milord, there was a good 4 years of our lives, Milord. Mr. Dotto was the captain, he was the vice captain, and I was the foot soldier.
Not
Milord,
foot soldier, not foot soldier.
lot of very fond memories. I'll go at 4 o'clock and talk to him. Lord,
let-
Monday, my lord, if we
মানে
can come.
মানডেটা না মানে ওয়েনসডে একটা লিখে দে আমি তাহলে ওদের দেখাই
My lord, what-
Send an email or
মানে
something.
let them take their time, let them give us a
What we will
proposal tomorrow, we will consider it.
Yes, yes, absolutely.
Oh, my lord, what
No-
I'll do is,
No hurry on that.
I'll find out, sit with my learned friends
Yes,
and do
better.
this. If first you cover 2 months of
Necessary, Mr.
consumption.
Chaudhary, you have a short conference also with whoever is the
Yes.
officer, because that will help your learned friends also.
So that, my lord, at no time is the electricity board under, my lord, a risk of exposure without a security.
And Mr. Chaudhary, you take one or two alternatives also.
Yes.
So that can be placed before them as alternatives. 1, 2, 3, they'll
And
choose.
we'll try it out.
Very well.
Better than, my lord, arguing dry propositions of law.
Exactly, I'm leading
It's
nowhere.
a commercial matter.
It's a commercial matter.
That's why. Boils down to that, having money.
I must make them happy. They must be
At
secure.
least viable, commercially viable alternative must be given.
It must be, they must be
Otherwise they-
secure for their exposure. And
True.
then, my lord, they will do something for me.
Yes, yes, that's a fair proposition.
My only difficulty is that, my lord, when Mr. Chaudhary will be sitting with his clients,
Yes.
what has happened in July, the disconnection was affected. 2022 July. In the at the end of the month of August, they came up that we will give another undertaking. It was restored. That undertaking also failed. Again, we had to disconnect on 1st of August.
My lord, iron and steel for the last 4 years is in a very bad situation because of China. The government has now, my lord,
Then we will not be able to meet.
no, the government has now improved it with, my lord, anti-dumping restrictions, etc. And international sale of iron and steel was, my lord, in a quandary because China was pumping in at a much lower cost. But now things have improved. ArcelorMittal lost some of their plants.
Very well. During arguments, comma, a scope of resolution of the dispute out of court has arisen in view of the petitioners giving certain offers of settlement to the respondents. First up, in order to finalize the offer of settlement and to extend the same to the respondents, and for the respondents to decide on such issue, comma, let the matter stand adjourned till May 10, 2023, when it will be listed
Can
under
it
the
be
same.
May 11, man? I'm so sorry, man.
Very well, May 11. No difficulty, May 11.
কে মেইল রত্নাঙ্গদা বুধবার থাকবে তাহলে বৃহস্পতিবার করবো
Tell me when. Yes. May 11 is Thursday.
মেইল
11.
because
May 11. তাহলে May 10 না করো না, May 11, 2020. Come back on that date, let us see.
Grateful to your lord.
If it's possible, all
Let me
concerned
try.
are saved.
Yes.
তারপর যে দুটো আছে, সরি, এটা নিল, এগুলো আছে, বইগুলো সব আমাদেরই। Yes.
From month list, item 96.
Chief 96, I am for the CSC. Mr. Mukherjee is appearing on behalf of the CSC. He's on his legs in court number
Every
1.
day this is being adjourned on some reason, either due to paucity of time, due to the court's
But
fault.
let them start, let the Lordship, if the
think that
matter
you-
can be taken up tomorrow in any way
See, I
possible.
have no difficulty, subject
can
to what you
understand.
learned friends, because they are in difficulty.
But CSC is required to be addressed.
CS is required to be heard.
Yes, yes.
If that is the
It's
situation.
my connection which is being disconnected, man. Earlier, a similar, on similar ground, a writ petition has been filed that how can a connection be given in the name of a dead person, my lord? Your lordship, that time I argued like, if it cannot be given in a name, that
It is on the merits. What should I do? I mean, they are asking for time today. CS. Whatever you say.
My lord, whatever my lord decides. Like,
An adjournment is sought by the CSC Limited, full stop, learned counsel appearing, you are for respondent number?
I'm for the private respondent 3.
Learned counsel appearing for the private respondent submits that the private respondent is without electricity connection, and in view of the urgency of the matter, comma, the same may be decided expeditiously. Full stop, be that as it may, comma, since the CSC
My
Limited,
lord,
My
Mr.
learned
Mukherjee
friend
is
has
here.
come.
Mr. Mukherjee is here.
you'll pay costs of 10 rupees to your learned friend for the private respondent, for the anxiety. Tanmay, বাদ দাও, কেটে দাও। Yes, move the word.
Yes, my lord. My lord, the read petitioner, my lord, has challenged a notice, my lord, appearing at page 25 of my read petition. My lord, kindly, may I place the impugned notice, my lord?
Yes, 25.
Yes, page 25
Right.
of my read petition. My lord, you will see, my lord, there are several inhabitants were addressed in the said notice, including the read petitioner. My lord, at the third row of the said notice, third name from the bottom, Nandlal Khuntela.
Yes.
Yes, my lord. The read petition concerning the connection of Nandlal Khuntela. My lord, he was my tenant. From the affidavit in opposition, it appears that he died in 2016. Now, my lord, may I place the content of the notice? The matter was referred. Earlier read petition was filed by me, WPA number 4983 of 2023. That was referred, and thereafter, pursuant to the order dated 14th March 2023, passed by his lordship, wherein his lordship was pleased to dismiss the matter, thereby rejecting the prayer of the petitioner in the aforesaid matter. We shall depute our men on 30th March at 12 noon at premises number such and such for reconnection of meter under consumer number such and such at the existing meter board position. You are requested to keep open the meter room and provide free access to the meter board service position. In case default, we will be constrained to disconnect your supply lines in terms of section 163 of the Electricity Act, read with clause 8.4 of the West Bengal Electricity Regulatory Commission of 2013, and disconnection shall continue till access to the meter board is denied to us. My lord, this was the notice served upon me. Against this notice, I have come up before your lordship. When the matter was heard on 30th March 2023, I made submission before your lordship, because in the earlier judgment, earlier read petition filed by me, I made party to the private respondent in that read petition, where I said that he is attempting to impersonate Nandlal Khuntela, who died long back. I didn't know the exact date of his death. And further contended, a connection or a reconnection cannot be done because at the instance of a third party. That was my contention in the read petition. Now, my lord, may I also indicate on sometimes in December 2022, the connection was disconnected. For what reason, I was not aware at the relevant point of time. Read petition filed on 14th March, matter was taken up when the CSC took a stand before your lordship that the contract was expired between the Nandlal Khuntela and the CSC because of a flux of time. 6 months has expired. Further submission was made that his son, Moonlal Khuntela, Mulchand Khuntela. Now here is another dispute from the affidavit on opposition.
Chandalal.
Yes.
What's the dispute?
CSC recognized Khuntela. Applicant is Khunteta. I don't know who is it and how the application was accepted and processed. So this was the second assertion was that his son has applied for a new connection. So I don't have any locus to file the writ petition and object his connection, and the contract is otherwise expired, so nothing remains in the writ petition. Based on such submission, my writ petition was dismissed. Now, based on that particular order, this notice was issued.
Your writ petition was for disconnection of that line. What was the relief sought?
My contention was reconnection should not be done.
Very.
Because the consumer has already died. That was my contention in that writ petition. Now, your lordship has seen the impugned notice. In the impugned notice, very first paragraph says, in the very first paragraph, they said that, my lord, kindly come to page 25 once of my writ petition. The very first paragraph says, by an order dated 14th March 2023, his lordship was pleased to dismiss the matter, thereby rejecting the prayer of the petitioner. So my prayer was rejected. So in the second paragraph, they said that we are entitled to restore it. Now, in such premise, I filed the writ petition. Now, your lordship, while hearing my writ petition on 30th March, prima facie of the view that the notice is illegal and cannot be given effect. So the CSC was restrained to give any effect to the notice.
Why? Because before any instance of resistance, this was given, the notice was given. On what ground
it is contended by the CSC in the affidavit that they face some resistance, but no documents.
On what ground did I grant that injunction, grant that order?
My lord, kindly come to your lordship's order, my lord, 30th March.
There is no ground.
No. On there are several issues. First, in terms of 163 of the 163 of the Electricity Act, upon facing resistance, the CSC has to give notice to the consumers that he will disconnect. In this impugned notice, they straight away issued said that I will disconnect it if you don't give me access. This is number one. Second issue, how a deceased can be addressed. These are the issues required to answer by the CSC. Third issue was, because on that day, CSC submits before your lordship that a reconnection request has already been placed on 11th January 2023. So your lordship has also asked the CSC to answer as to how, after the death of a consumer, a reconnection request can be made at the behest of a third party.
The private respondent has sought for a reconnection or a fresh connection?
No, private party herein, my lord, is nobody. He is the grandson. He is the grandson. That is why, my lord, I repeatedly saying he has no locus to make any submission. The applicant, according to the CSC, is his father. Now I will take to the notice the reconnection. That is itself in contravention to the provisions of regulations. And my lord, there are two scenarios. Reconnection can be made by the consumer only. If disconnection is
the
done,
first ground was whether a third party can make an application.
Under the provision, there is no scope. A third party
Secondly, whether restoration could be given in the teeth of the order, where it was specifically.
My lord, kindly take your.
The contract had expired. They had said that.
Yes,
the second ground, and thirdly, deceased person in the name of a deceased addressee.
My lord, kindly take the opposition of these affidavit in opposition of.
Place your case. Yes.
Yes, my lord. My lord, now, my lord, kindly take your lordship's last order, 30th March, my lord. That is actually dated 30th January 2023. Later on, it was rectified.
Yes.
My lord, kindly come to page 3.
Now I've seen the three grounds. These are the three grounds. The first ground is how electricity connection of a deceased were reconnected, behest of a third party.
Yes.
First ground is third party.
Yes.
Second ground is in the teeth of that order,
Yes.
where it was recorded that the contract has expired.
Yes.
Second, so in the capacity of a son, whether he can apply at all.
Yes.
And the third thing is the addressee of the notice was a deceased person, so notice is bad.
Yes.
These are the three grounds.
And my lord, 163 also. Section 163
Yes.
also. Whether without affording any opportunity, this kind of notice can be issued or not. Because this situation will only arise if the CSC face resistance by a particular consumer. In my case, no resistance has faced. He has straight away said that you will give me, otherwise I will disconnect. And they have referred the provisions of regulation 2013 also, which I will show to your lordship, that also says otherwise. Act 163 subsection 3 says, if you face resistance, thereafter you will give notice. Then disconnection will be done. And the rules also says that, regulation 2013. Now, my lord, in the given facts and circumstances, now the CSC, what in the opposition, what they are attempting to make out a case that, first, my lord, my humble submission, 14th March 2023, the order passed in the previous order. I will, that is a part of this writ petition, my lord, I will show it. It was contended on the earlier occasion by the CSC that erroneous submission was made by the CSC. So the order was passed. If I take it, the submission of the CSC, that erroneous submission was made, contract was not elapsed by a flux of time, and fresh application was not filed by the son. That is contended by CSC in the opposition. Then, my lord, this notice is apparently bad. Because at one hand you are saying wrong order is passed because obviously wrong submission made by the CSC, and on the other hand you are giving effect of the said order. Absolutely no answer to this. My humble submission, that order is otherwise attained finality. This order was passed at the present of both the parties, the private respondent as well as the CSC. They participated in the proceeding. Till now, there is no application in such writ petition. This is not a continuation of proceeding. I got a fresh cause of action, I filed a fresh writ petition. It is, we are not at an appellate stage. So that order is otherwise attained finality. Till date, neither the private respondent nor the CSC file an application or by any other method saying that no, some erroneous submission was made, kindly modify the order. No such request before this honorable court. So first, my submission is, rightly or wrongly, that order has attained finality. Now, so far the issue raised by the CSC, my lord, kindly take the affidavit once. Opposition filed by the CSC. Yes. Today their stand is, it is a reconnection application filed by the son, not a fresh application. Whereas in the earlier writ petition, they said it was a fresh application. They are saying contract is not expired because the disconnection was done for non-payment of dues on 16th December. For the due of from May 2022 to November 2022. My lord, may I refer page 2 of the opposition? Paragraph 3A. The meter bearing number standing in favor of Nandlal Kuntela was disconnected due to non-payment of consumption bill from May 2022 to 11/2022. The supply was disconnected on 16th December 2022. I pause here for a moment. Now, it is an admitted position that disconnection was done for non-payment. I will refer to the provision, your lordship. If the disconnection is done for non-payment of dues, it is only the consumer who can apply for reconnection, not a third party. Now, thereafter, my lord, it is stated that the entire outstanding amount of rupees such and such was paid on 11th January 2023. In view of the said payment, one Mulchand Khuntela applied for restoration. So obviously this application was made on 11th January 2023.
And
not-
name transfer.
Yes, and name transfer. I will show the document itself. The document is also in contravention to the provisions of regulation. My lord, then my lord, on 22nd February, a copy of the said application is annexed here to and now my lord, kindly take the document. The document is appearing at page 10.
Yes.
Of the affidavit. My lord will see the form is for reconnection of supply. Reconnection of supply. The first paragraph of the form says relevant documents regarding bona fide occupation of the said premises are enclosed here. No such documents here enclosed. My lord, now my lord, kindly turn to the next page. The address is given, and my lord, may I also say, it is a commercial property, not residential property. Applicant's name, Mulchand Khunteta.
Signature is also there.
Yes, Khunteta. Whereas in the CSC document says it's Khuntela. And your lordship kindly see, it's a request for reconnection. So where is the statement? Mulchand Khunteta cannot be an applicant. He has to be a consumer. Because by that time, he was not a consumer. Nandlal Khuntela was a consumer in the record. Now the Mulchand Khunteta has also signed it. Now, my lord, kindly come to the next page. This is the application for change of name. Second page. And kindly note of it, your lordship, there is no document with the application.
So this is the transfer application.
My lord, may I refer? First of all, transfer application has to be in form of 2010 regulation. As per Annexure A1, I will show to your lordship what is Annexure 1 from the regulation. Now, my lord, kindly take page 12. This is the request. Now there is no date. Date is blank. Now thereafter, who is writing it?
You are the owner of the property.
I'm the owner of the property.
Yes.
Now, who is writing it? The supply at the above address stands in the name of Mulchand Khunteta. This is wrong. No mention of Nandlal Khunteta, and the applicant is also Mulchand Khunteta. And the CSC is, without any documents, a defective application, not in form, proceeding. Is a statutory body discharging a statutory function, discharging his function like this, and on the contrary, threatening me that I will straight away disconnect your line if you don't give me access. Now, my lord, not only here, my lord, kindly take the next paragraph. Please arrange to transfer the supply in my name from the above named consumer. Above named consumer is Mulchand Khunteta in the application form states. So where is the verification?
This is obviously a mistake.
Now,
even if mistake, it remains a mistake.
My lord, I will restrict my argument. My lord, I will not enlarge the scope of the repetition. I do not need to, because when the situation will come, I will obviously take all these points. Obviously, I can to me reconnection korabe. May I show?
So your grievance is against the disconnection notice?
No, yes, the impugn notice. I am saying that
your entire writ petition is against the disconnection notice.
His grievance
Lord,
is probably not to give electricity connection to the tenant.
No.
Your grievance is in this writ petition, it is entirely on the disconnection notice.
No, not disconnection notice.
You have challenged that page 25, you said. That
yes, it's a not disconnection notice. It's a reconnection notice. Disconnection has done already. Now they are trying to attempt to reconnect.
No, can you reopen that chapter after the previous order?
I'm not, I want to go by the order. It is their contention.
You wanted to stop the reconnection, which was not allowed. on whatever submissions being
Yes,
made.
yes,
there.
yes, yes.
That was not allowed. That has attained res judicata. Now, after that, can you make the same prayer here? Again, don't give reconnection.
I'm not
This is my
saying,
simple
I
question.
am saying what my contention in the read petition, if be that as it may, whatever order is passed there, let it be there. I don't want to interfere it.
Suppose that
I'm-
remains. Yes.
Yes, I am saying, kindly take the impugn notice once. Kindly take the impugn notice. If the stand is, the order is remain valid in 14th March 2023, then
For reconnection of meter.
reconnection of a dead person should not be allowed. Because Nandlal Khuntela doesn't exist today.
What had you challenged in that? You had, I mean, they had applied at that point of time for reconnection.
I was not fully aware, no affidavits were exchanged in that read petition.
Is it recorded in the order, something on that? That reconnection.
Yes, yes. My lord, may I refer the order? That position will clarify. My lord, kindly come to page 21. The order is annexed here in my read application, my lord. Page 21. My lord, I will start from the third paragraph. No, from the beginning, my lord.
From the beginning, better.
Yes, yes. Learned counsel for the petitioner submits that the petitioner is a landlord in respect of the premises where, due to non-payment of electricity bill by the deceased grandfather of the private respondent number 3, the electricity line standing in the name of the said deceased was disconnected. It is submitted that now the private respondent is seeking a new connection, restoration of connection, without seeking a transfer of the electricity meter in the own name. Learned counsel appearing from the private respondent contends that the private respondent's father, that is the son of the deceased original consumer, has already paid up outstanding dues, which stand is supported by learned counsel by the CSC Limited. Moreover, a new electricity connection has been applied for by the father of the present private respondent. So it was contended, new application, new electricity connection application was filed. It is thus submitted that there cannot be any impediment in giving such connection to the father of the private respondent. I have no difficulty if applied for a fresh connection in accordance with law, given. Now, my lord, however, since the landlord is putting up resistance to
Mulchand
the
is
CSC
the father. Mulchand is his father.
Yes. Personal in having access to the existing meter board position at the premises, such connection is not being given by the CSC Limited. Learned counsel for the CSC Limited in addition submits that reconnection charges are required to be duly paid by the new applicant, that is the father of the private respondent. It is further contended that after the expiry of 180 days from the date of disconnection for non-payment of outstanding dues.
These two paragraphs, they now say that it is not correct. Let us proceed on the premise this is correct.
Yes.
For the time being.
Yes. If it is correct, then Nandlal Khuntela connection cannot be restored. Because the notice says, since just because my writ petition was dismissed, they should be allowed to reconnect it because it is their own contention is saying.
But
so they
your
cannot
present writ petition is your cause of action. You have locus standi to challenge only the disconnection threat, because regarding the reconnection, which they have averred in their notice, that you cannot reopen now after this order. Whatever is the premise of this order.
Yes.
This order refuses that prayer of yours.
So in that event, CSC is also stopped.
From doing what?
From reconnecting the connection.
You cannot take that plea. You are debarred because of res judicata, the previous order. After that, you cannot reopen the question of whether reconnection can be given to them. That was any appeal preferred against this? You could have preferred an appeal against this.
My lord, kindly visualize the situation.
Visualize totally.
Yes. My lord, my earlier...
Visualize totally. That's why I'm saying what I'm saying.
My lord, my earlier writ petition was not entertained because of these two reasons. That
it was not entertained. No.
Fresh application has been filed and the contract is otherwise elapsed. So my writ petition was not heard on merit. I did not get an opportunity to argue my case because the contention raised by them that The issue raised in that writ petition was otherwise infructuous because of two reasons. First, contract is expired, so reconnection cannot be done because the contract itself expired.
But a liberty was given to his father
Yes,
to pursue his application for new electricity connection.
so he can pursue it, but
But that new electricity connection permission was given on the premise that this contract had expired.
no new connection. Kindly
Now they are asking reconnection. Well, if you say that they are entitled to, as per this order, they are entitled to reconnection.
No, new application. Reconnection is contravention to the law.
Give them liberty to file a new
My lord,
application.
kindly
Whatever they have paid will be adjusted with that.
my
Tomorrow
lord,
they will
kindly
apply.
appreciate.
Day after they will
My
give
lord,
the
kindly appreciate. CSC being a statutory body, discharging a statutory function.
Even if you are
is bound
right,
by the regulation.
reconnection now, fresh application for reconnection cannot be prevented by you.
Reconnection cannot be done because the rules or regulation doesn't
That point you
provide
cannot
so.
reopen now.
New
After this.
application can be done. Only new application. Reconnection is not possible. May I?
Very well, very well. New connection can be made by them as per
Yes. Reconnection cannot be possible.
So I'll record your prayer. If I record your prayer and say that you are taking that point as per this order, which is justified, suppose. So new connection can be made and that liberty was given to them. You cannot prevent them from taking that new connection then. After this order, however, it is made clear that nothing in this order shall preclude the new applicant.
My lord,
that is-
obviously, if in accordance with law, if he'll apply, I don't have any authority to object, but it has to be in accordance with law.
You have no authority to object in any by any means. You have no locus
My
standi.
lord, why it's
You have no
necessary?
locus standi.
My lord, kindly, I have
You
no
can be
difficulty.
aggrieved with your
My
threatened
lord, I
disconnection.
have no difficulty. The whole difficulty is this Moolchand Khuntela doesn't stay here. He stays. My lord, for fresh application, he has to establish that he's a occupier of the premise.
Definitely he has to.
Yes. So that is why if the new
Satisfaction of the CS.
so my lord, new application is filed and pursued by them, I have no difficulty in accordance with law, but not on the basis of just.
What is your locus standi to challenge this? Even if they
because
don't
I'm
apply.
aggrieved, I'm aggrieved by the notice. I'm one of the addressees.
What is only the disconnection portion?
My lord,
You are not agreed by anything,
My lord,
cannot be agreed by anything.
My lord,
else.
I have brought this issue before this honorable court. My lord, the CSC at one stage
It's not a public interest litigation.
no,
And you are not a
my
public
interest-
by
my
yourself.
lord, my interest is hampered.
Yes.
My interest is hampered.
Your interest has been settled by the previous order. Regarding
But-
this
but-
reconnection
but
or
it is-
new
But
connection.
it is their own stand that it was a erroneous submission. The order was passed on an erroneous submission.
I'll deal
Now-
with that. This is a frivolous writ petition.
My
Sir,
lord,
by hook or by crook, you are trying to
my
prevent
lord,
them from
what I'm
getting
seeking
connection.
today, my lord, let him file a fresh application because reconnection regulation itself doesn't provide the provision for regulation. May I just give
No,
him-
we
I
can
will-
always
I will
change the
show
name and
I
reconnect.
will show the relevant provision. If it is permissible in law,
Being a landlord, why not
the
can he?
connection can be reconnected. But from the regulation, it doesn't provide. So. My lord, may I just place the relevant provision?
Regulation does not provide what? The consumer himself has to reconnect, seek reconnection.
Yes,
that
my
is
lord,
what is
my lord,
provided.
there are two scenarios. If a reconnection request was made before disconnection by the
If a
legal
new application for electricity is made, you have no objection.
of course,
I'll record that.
in
Permit, grant
accordance
them
with the
leave.
law, my lord.
They'll file the new application for electricity connection.
In ac-
Whatever amount they have paid, that will be adjusted by the CSC Limited with that, and a new connection will be given. to
Yes,
them.
yes, in
We
accordance.
will- my lord, we will not adjust, we will
accordance with-
refund that money
Yes,
and we will,
Better,
yes.
still better.
yes, in
still better.
accordance with law.
and we will remove the earlier meter which is in the
Yes,
name
yes,
of
yes.
the deceased.
Because that is the regulation says it has to be disconnected. Fresh application has to be.
And regarding your possession, you have proof he has given something.
My lord,
No, nothing.
my lord, if I can say,
My lord, let him file
My
a
lord,
fresh application.
my lord,
No difficulty.
they are, what happened is, my lord, they can break the lock and they can enter in because it's an office premises, my lord, and they are very powerful there, my lord. Reconnection,
Don't speak for the CSC Limited. You say what you can do.
my lord, that.
What is your locus
My
standi?
lord, one
What is your locus
my-
standi?
my- I'm-
What is your locus standi to apply for a new connection? Are you in occupation?
My lord,
Answer my query. Show me the proof.
my lord, let me file.
So file it before the CSC Limited. I'll give you liberty to apply for a new connection. Get the new connection. They'll refund whatever amount you have paid. I'll record his submission and he's correctly submitting as per the previous order. This cannot be done.
So let the son of the deceased apply, man, as they have asked for.
My lord, that 180 days.
No, son of the deceased, I cannot give him a new right.
No. Whoever be the occupant. This is the law.
My lord,
It can't be.
my lord,
Successory
I
right is
can
not
say,
there.
my lord,
No
on the last
successory right.
occasion, my lord,
Please take your seat. Please
My-
take your seat. Mr. Mukherjee, take your seat. Yes.
on the last occasion, 180 days submission was raised by them that 180 days have crossed and all that. They have taken that point, my lord. On that, CSC said that I was
Agreed. CSC said yes, contract has expired.
my lord,
That was recorded at least in the.
because it was the writ petitioner.
It has come up from CSC.
Yes, they are saying so. That's a mistake on their part. They're saying that. But no correction application, rectification application has been filed. He's right on that. That no modification application has been
applied for.
then that order remains.
But on when when this matter was first taken up by your lordship, this writ petition, I appeared before your lordship.
Pointed out,
And
yes.
the first thing I pointed out, my lord, what has followed?
Your bona fide is not in dispute, Mr. Mukherjee. What is in dispute is whether this point can be reopened if this order remains on record.
My lord, we are agreeable.
We cannot reopen just like that.
What has fallen from your lordship, my lord, I think he has also agreed, my lord, pass an order, my lord, directing who is in occupation of the premises to apply afresh in respect of the new connection. We will inspect, and upon compliance of all formalities, we will give. And we will adjust the money, we will refund the money to the.
Refund, not adjust. Adjust was what I said.
And one subject removal of the meter of the.
Yes.
My lord, already we have filed then allow me to file affidavit. I have filed 107 and 144 of CRP.
May I have your lordship's time?
No.
Well, there is already a matter going.
So what? No. You're in the midst of a matter. And it's only 3:11. Yes, Mr. Mukherjee, please.
I'm grateful.
Take your seat. Learned counsel for the petitioner argues that the impugned notice dated March 23, 2023, issued by the CSC Limited is dehors the law and illegal in several respects. First, it is submitted that a third party cannot apply for restoration of an electricity connection standing in a name of a different consumer. In the present case, it is submitted, the original consumer, Nandlal Khuntela, has expired, and thereafter, the private respondent, you have implemented the son of grandson.
No, initially I did not. By an order of court, I implemented.
So
Yes.
father is also party, son is also.
No. I did not make any one party.
Very well.
Yes.
Ki bolna? Number 3 is seeking a restoration of such electricity connection which he is not entitled to under the law and/or the regulations. Next para. You are saying that your father has applied.
My lord, and we have already filed a writ petition also, which will appear with your lordship.
Next para.
A similar matter.
It is next argued that the contract with the deceased erstwhile consumer was submitted to have expired on the last occasion, when a different writ petition had been filed by the present petitioner bearing WPA 4983 of 2023 and was recorded in the order passed in the said writ petition. By placing reliance on the said order dated March 14, 2023, learned counsel for the petitioner points out that it was recorded in the said order specifically by the court that the CSC Limited had submitted that reconnection charge. The CSC Limited had contended that after expiry of 180 days from the date of disconnection for non-payment of outstanding dues by the erstwhile consumer Nandlal Khuntela, the contract between the said consumer and the CSC Limited had expired. It was also recorded in the said order that the contract between the erstwhile consumer within bracket since deceased bracket closed and the CSC Limited had already expired as per the statute upon the expiry of 180 days from the date of disconnection on the ground of non-payment of outstanding dues. Full stop. On such premise, comma, it is argued, comma, the present petitioner's prayer in the said writ petition, comma, for disallowing the reconnection sought by the private respondent was turned down. Full stop. Next para. However, comma, at present, comma, it is evident from the impugned notice that the CSC Limited is admittedly trying to reconnect the meter of the deceased erstwhile consumer, comma, which is not permissible under the law. Full stop. Next para. Next, it is submitted that the notice in question was issued against several persons, comma, including the deceased erstwhile consumer Nandalal Khuntela, comma, which is also bad in law. Full stop. Next para. That apart, comma, on merits also it is submitted that the purported notice under section 163 of the Electricity Act 2003, what happened?
My lord, CSC is not trying to connect the connection in the name of a dead person.
Take
my
your
lord.
seat. Take your seat. You have not followed what I am saying. Just কোথায় ছাড়লাম সেখানটা বল? Is bad in law since there was no prior resistance on the part of the petitioner to invite the CSC Limited to invoke the provisions of section 163 read with clause 8.4 of the WBERC within bracket Electricity Supply Code bracket closed regulations, comma, 2013, and threaten disconnection of the petitioner's electricity supply at the premises. Full stop. It is submitted that since the petitioner is a landlord of the premises, comma, there was no occasion for the CSC to threaten such disconnection. Full stop. Next para. Learned counsel appearing for the CSC Limited reiterates the contention of the CSC, comma, which was made at the outset in the present writ petition, comma, to the effect that under a bona fide mistake, comma, the CSC Limited had submitted in WPA 4983 of 2023 that the contract between the erstwhile consumer Nandalal within bracket grandfather of the present respondent number 3 bracket closed had expired after efflux of 180 days from the date of disconnection. Full stop. Next para. It has subsequently been ascertained that the time period of 180 days had not actually expired and the said contract was otherwise live. Full stop. Next para. It is submitted by learned counsel for the CSC Limited as well as the private respondent number 3 that there is no bar in the private respondent, comma, who is in occupation of the premises in question, comma, to apply for a fresh electricity connection in respect of the premises. Full stop. Next para. Moreover, comma, since the CSC Limited is now of the opinion that the contract between the erstwhile consumer and the CSC Limited never expired by efflux of time, comma, the application of the petitioner for restoration of such connection, comma, along with transfer of name of the same is maintainable in law. Full stop. As regards the notice being bad due to absence of previous resistance, comma, learned counsel for the CSC Limited disputes the same and submits that as mentioned in the affidavit in opposition of the CSC Limited, comma, resistance had been faced by the CSC Limited when the CSC personnel went to give such connection to the private respondent, comma, which occasioned the issuance of the notice under section 163. Full stop. Next para. Upon a perusal of the order passed, an order dated March 14, 2023, passed in WPA 4983 of 2023, it is seen that it is seen that learned counsel for the petitioner is justified in arguing that in view of the recordings in the said order, where it was inter alia observed that the contract between the erstwhile consumer Nandalal and the CAC Limited had expired, there could not be any further occasion to seek reconnection, that too by a third party. Full stop, next para. Moreover, if the contract had actually expired, there cannot be any occasion for transfer of the name of the deceased erstwhile consumer to the name of the present applicant, that is the respondent number 3 and or his father, since in such event, the said respondent and or his father do not step into the shoes of an existing consumer in view of the contract having already been expired. Full stop, next para. Although it is now submitted by the CSC Limited that the submission regarding the contract between Nandlal within bracket since deceased bracket closed and the CSC having expired was the result of a bona fide communication gap, in the absence of any application for rectification or correction of the order dated March 14, 2023, passed in WPA 4983 of 2023, the said order cannot be deviated from, having attained finality. Full stop, next para. Within the limited scope of the present writ petition, the court is to consider the legality and or validity of the impugned notice dated March 23, 2023. Full stop, the petitioner is legally correct in arguing that the notice could not be given in the name of a deceased person. Full stop. However, it is seen from the said notice that the same pertains not only to the deceased Nandalal Khuntela, but also the other residents at the said premises, none of whom have come up in challenge against the said notice. Full stop. Although the notice is bad with regard to Nandlal Khuntela, in view of the insistence of the petitioner on the observations of the order dated March 14, 2023, made in WPA 4983 of 2023, such issuance of notice in the name of a deceased person, whose contract has already expired, cannot have a direct bearing on the validity of the notice otherwise. Full stop, insofar as the petitioner is concerned, the petitioner is the landlord stroke occupier of the premises, and insofar as the landlord petitioner is concerned, there is no incongruity in the notice with regard to the component of the same having been issued in the name of a deceased person. Full stop, next para. Insofar as the argument made by the petitioner that the respondent number 3 and or his father are not entitled to seek a reconnection or transfer of name, there is substance in such contention in the light of the order dated March 14, 2023, passed in the previous writ petition, which still stands intact in the absence of any application for rectification of the same. Full stop. However, proceeding on such premise, nothing in the statute or regulation can prevent a different occupant of the premises, including the present respondent number 3 and or his father, that is the son of late Nandlal Khuntela, if they can show their occupation prima facie before the licensee, to apply for a new connection of electricity at the same premises. Full stop, next para. Since, in the present case, no specific averment was made by the CSC Limited with regard to any previous resistance having been offered by any of the notices, to invoke section 163 of the Electricity Act, 2003, and in view of the CSC Limited having pleaded reconnection of meter of the deceased Nandlal Khuntela, which is not permissible in law, the impugned notice is otherwise defective and cannot be acted upon by the CSC Limited. Full stop. In view of the above discussions, the WPA 7862 of 2023 is disposed of by setting aside the notice dated March 23, 2023 on the grounds as indicated above. First up, the CSC Limited shall be restrained from further acting on such notice. First up, however, nothing in this order shall preclude the respondent number 3 and or the father of respondent number 3 and or any other occupier of the premises in dispute from applying for a fresh electricity connection in respect of the premises. First up, if such an application is made, subject to satisfaction of the CSC Limited with regard to the occupation of the applicant and upon compliance of all formalities under due process of law by the applicant, the CSC Limited shall give such connection to such applicant. Full stop. Next para. However, since the respondent number 3, on an erroneous notion has already deposited substantial amounts of money in pursuance of his application for reconnection stroke transfer, applications for reconnection stroke transfer, the CSC Limited shall refund such amount, paid erroneously to the respondent number 3 within a fortnight from date. Full stop. Next para. If an application for electricity connection is made, in accordance with law, subject to compliance of all formalities, the CSC Limited shall give such connection, preferably within a fortnight from the date of such connection, such formalities being complied with. Full stop. No rest to cause or incident. Thank you.
At the existing service position.
At the existing service position.
Lord, the only thing
Subject to removal of that previous meter.
As a full stop, arekta line add kore daw. The CSC will also be at liberty to remove the electricity meter standing at the said premises in the name of the deceased Nandalal Khuntela, expeditiously.
My lord, if I can, however, the landlord in the said writ petition, my lord, it was already in the last order, my lord, have recorded, since the landlord is putting up resistance to CSC personnel in having access in the existing meter booth position, my lord has said, like, they have said that notice is bad, my lord, it has been recorded in the last order that the landlords were putting resistance, that is in page 22, my lord. That is why, and we have already filed 107.
Get the server copy of the order, go through the order, line by line, you'll get your answers.
My lord, in the order, my lord, your lord
My lord,
has
one indulgence, if I can ask.
it is recorded residence. This is not a residential premise, it's a commercial property, my lord.
Residence in what corner? Residence যদি কোথাও থাকে control find করে contact to block.
Consumers will.
Occupied property.
No, or inhabitants.
Residence যদি কোথাও দিয়ে থাকে সেটা bold করে দিবে।
Yes.
Residence বা inhabitants.
Yes.
My lord, if I can ask for one indulgence, my lord, let there be no obstruction from the writ petitioner, my lord. The land.
Let them put up obstruction. That will give opportunities for you to, for me to have the privilege of hearing all of you.
My lord, already on a similar matter.
On anticipation, we cannot. You have to first apply for that reconnection.
My lord, 3 times they have registered, my lord, for the restoration of this connection.
4th time may happen. Yeah.
Grateful.
That will be on apprehension.
Great.
Thanks.
Assigned matter item 98.
This is the 3rd consecutive occasion when none appears for the parties. Full stop, on April 3, 2023, comma, a last chance was given to the petitioners to move the matter. Full stop, even today, since none appears for the parties, comma, it transpires that the petitioners are no longer interested to move the matter. Accordingly, WPA 17786 of 2013 is dismissed for default without any orders to cause. Interim order, if any, stands vacated. Shall stand automatically vacate. দুটো আছে তো? Yes, you are appearing in one of the matters. Rest of
99, my lord.
99.
My lord, earlier occasion, I thereafter, as per direction of the lordship, my lord, I contacted that there is one, namely Joita Sinha, and I tried to contact over telephone and give notice, but not availability. She was not in court. Thereafter, I informed that matter is
give a written notice. When can you give it?
Written notice. My lord, today, my lord, is not today, my lord. Or not this week, my lord.
I think not this week will be better for you.
Not
If you
this
want
week, my
to
lord.
track her out and
Yes,
then.
yes, yes. I informed the
Very good.
telephonic.
Learned counsel for the petitioner submits candidly that despite attempts by the petitioner, comma, no notice could be served on the learned advocate appearing for the respondents. Full stop. Hence, comma, further time is sought by the petitioner to give such notice to the advocate on record for the to the advocate for the state. Full stop. Next para. Accordingly, let the matter stand adjourned till May 8, 2023. Full stop. In the meantime, the learned advocate on record for the petitioner shall serve a notice to the advocate appearing for the state, indicating the intimating the next returnable date. 8th Monday.
Yes, grateful. 8 May. Grateful, my lord.
Thank you.
100, 101.
For the petitioner, my lord.
Yes, Mr. Nag.
Last occasion, my lord, direction was passed, my lord, to file affidavit in opposition. My lord, in this matter, Rutuman Bhattacharya is appearing. I think.
Oh,
My lord,
Praying for an adjournment today.
my lord,
the day.
my lord, I am told, my lord, he will rejoin from the mid of June. So it's
No, he
better
appeared online in a matter.
online in a matter, I know. But
So I don't know whether he will be able
he
to
said,
appear.
he said that he will be joining court from the month of June, mid of June. So it's better to keep the matter in the monthly list of
Very good.
July, because every
Yeah,
time
unnecessary uncertainty.
Yes.
An adjournment is sought on behalf of learned counsel for the respondents. Full stop. Let the matter stand adjourned till after the upcoming summer vacation of this court, and shall next be listed in the monthly list of June 2020. Let it be on the month
July. Let it be
July.
July, because he will join. He told me that in the
No,
mid
no,
of
he'll be joining before that. Monthly list of June. Let us see. If
Lordship.
necessary, I'll grant further adjournment.
Lordship.
সব শেষ? No further matter.
Until this.